Good afternoon, everyone, and welcome to the Joseph A. Vail Asylum Law Workshop. We are so grateful to have y'all, and we have such a high attendance, which is great. I think we have over 500 registrants, and because of that, with the registration fees, we were able to raise thousands of dollars that will go towards the immigration clinic in order to assist the immigrant community. So thank you so much. So I hope you all enjoy the panels that we have planned for today. Just a quick reminder, during each panel, the first 45 minutes will be delegated to only the panelists to speak, and then we'll save the 10 minutes after that for a question and answer session from the audience, including those who are here via Zoom. We are also filming and recording this workshop, so please make sure that your phones are silenced and you keep your chatter to a minimum. And if you plan to ask a question to the panelists, please be sure to project your voice. And most likely one of the moderators will repeat your question in order for it to be heard over the recording. So we will begin our first panel, the Immigration Judges panel. And I'd like to welcome the Honorable William Zimmer, the Honorable Jimmy Benton, Elizabeth Mendoza, and Rosemary Vega. Thank you all for being here, and I hope you enjoy the workshop.
So good afternoon, really. So I think we're going to start with Judge Benton.
Very well. So a little bit of overview. I'm going to discuss Title 42, and Judge Zimmer is going to talk about recent Fifth Circuit cases that impact immigration. Rosemary Vega will definitely talk about humanitarian asylum, and Elizabeth will talk about best practices and some other topics. Okay. All right, so COVID-19 as progeny has wreaked havoc upon civilized nations, causing us to descend almost into cannibalism. So what Title 42 has been federal law on the statutes, on the books, for about 75 years. But it was enacted in March of 2020 as a result of the COVID-19 pandemic. It is Title 19 is a shorthand term for the Centers for Disease Control and Prevention order that bars entry and allows for expulsion of anyone without normal safeguards for those fleeing persecution at the southern border if there is a serious danger to the introduction of a communicable disease, which COVID-19 has been identified as. However, there are large groups of people who are exempt from it, including citizens, U.S. citizens, lawful permanent residents, and anyone with valid travel documents. But it does not allow for people who are simply seeking for asylum or withholding or removal to enter the United States. The Title 42 applies to asylum seekers at the southern border through two main mechanisms. One is the turnbacks of asylum seekers before they have reached the United States border or U.S. soil. They used to stop at the border crossing or checkpoints. The other is expulsions of asylum seekers who have managed to enter the United States without inspection, without documents, but are given what's called expedite removal. Both mechanisms apply to anyone seeking asylum at the southern border. Now, turnbacks involve all nationalities. This occurs when a migrant approaches an official port of entry at the southern border and expresses a fear or desire to seek asylum. In the past years, such action on the part of the intending immigrant or the undocumented individual would result in a incredible fear interview, and perhaps if credible fear or reasonable fear is found, opportunity to present a case before the immigration judge. However, that is not the case currently. In a vast majority of cases, the CBP officer who encounters the individual at the port of entry will turn him back. Although he or she, the CBP officer, does have the authority to allow individuals to enter the country under certain circumstances, but in the vast majority of these situations, they are refused entry. The second one is the mechanism is the expulsion. For those who enter the United States at a location other than a port of entry and are apprehended by the U.S. Border Patrol, they are given expedited removal and returned to Mexico. They are not considered to have been excluded, deported, or removed. They are not given alien numbers. They're usually given instructions on how to try and seek asylum by applying through something called the CBP application that will allow them to make an appointment to be inspected or interviewed at a certain time and place designated by the CBP officers. But in any event, they are returned and they have to then try and enter the United States by being paroled in. And if, again, if they try to come in again, they again be returned. And even though it's not considered to be a removal or deportation, it could affect a discretionary decision made on future applications. Now, the Biden administration has attempted to make the situation more palatable, recently authorizing 30,000 per year entrance from Mexico. No, it's not Mexico, but hold on, it's from Haiti, Cuba, and Venezuela. But the process here requires them to make applications in their country and then to enter the United States on parole for a year and then prosecute their claims. This is an attempt to reduce the deluge of folks at the southern border. Concerning those people who are unceremoniously returned, doesn't happen to everyone. Unaccompanied minor children are not treated that way. And the folks who are returned to Mexico, Mexico has to agree and has agreed to their return. But all countries are not treated that way. For example, if you're from Ecuador, because there is no agreement between the United States and Ecuador, people from Ecuador are not given expedited removal and Mexico not accept them. So they are given notice to appear and will eventually appear before an immigration judge. The same thing with countries, Russians, for example, or if there is a mixed couple where the wife is from one of the countries that Mexico is willing to accept for the expulsion, and the husband is from a country that is not recognized as being a country that Mexico accept, then that family will be allowed to enter the United States. So if those individuals are allowed to enter the United States under what's called the CBP-1 program, that's the ones who have used an application that the CBP has developed. You must be on the border. It must be able to tell that when you make your appointment to be interviewed, that you are on the border. And then the process is free. It's unfortunately, it looks like it requires some deal of sophistication on part of the intending immigrant with technology, and also to have a cell phone. But it's been a working process in progress, and there are only a limited number of appointments available, and the locations for the interviews are not everywhere, but along only certain enumerated ports of entry. But that's Title 42 for you. It's always a ongoing process of the current administration trying to find ways of getting around it. There's been lots of litigation on it, but for now, it's something that we have to live with.
Judge Zimmer, I think you're gonna talk about Fifth Circuit cases.
Yeah, I have a PowerPoint. I don't know if that's available. Is it on there?
Oh, I didn't realize that was what.
Oh, okay. Well, first of all, I just want to tell everybody, I'm really kind of. Yeah. Oh, can you hear me now? Okay, this thing. It starts off with a picture of a lawyer. Well, first of all, I want to tell everybody I'm really pleased and honored to be able to talk to all these people who have an interest in immigration law. It's something that I share with you, even though I am not actively on the bench at this time. So thank you for inviting me to come. The presentation I had starts out with a picture of a lawyer sitting on a curb, like this, for the Fifth Circuit. But it's not all that bad, because the Fifth Circuit issued six published cases in 2022, by my count, if I'm not mistaken. Two of them were actually favorable to the petitioner. And the other three, this has to do with asylum. It just focused on asylum. The other three contain a lot of interesting subject matter. So you could probably spend all day on these things. So I'm going to try to run through them and just give you the takeaway. And maybe might be some questions about it later. Now, the first one I wanted to talk about is actually not a published case. It's I can't even pronounce the name, but it's Enthusiasm Asylum v. Garland. The number of this is 20-60677. This case is a case out of Sri Lanka, and this person was a member of the Tamil ethnicity, and there was a pattern and practice established of the government persecuting this group. And what the Fifth Circuit came up with in this case was that in the absence of a presumption of well-founded fear of persecution based on a finding of past persecution, an asylum applicant who is found not to be credible cannot establish a subjective fear of persecution, even if a pattern and practice of persecution of members of the asylum applicant's ethnic group has been objectively proven based on credible evidence other than testimony. There was an adverse credibility finding in this case. It was not contested by the petitioner on appeal. There was no argument that he presented to oppose the adverse credibility finding, but he rested his case on the regulation that says if there's a pattern and practice of persecution, against a certain group, you don't have to show that you as an individual are singled out in the record. But and the Fifth Circuit in this case took pains to point out that that regulation, which happens to be it was at 8 CFR 1208.13 B2 III, is aimed at proving the objective side that you have to prove a person. Oh, there it is. So I'm taking pains to tell you what, but this is not in the PowerPoint. So that was how it is. So the reason I included this in this presentation is because it serves as a contrast between a published case that came later, which looks at it from the other angle of failure to prove an objective objective fear of persecution, a reasonable fear by a reasonable person. And so like it's just sort of I was telling some of the other panel members, it's sort of like when you want to change a dollar bill and it's not any good, and no matter which way you flip it, you don't get any coins. So if you can't prove you have a subjective fear, even though you can prove there's an objective side of it, fear of persecution, you have not met your burden. So that's the takeaway from that case. The next one is Rosario Aurora Sanchez Amador v. Garland. This is published April 11, 2022. And the case number's up there. In this case, an asylum applicant's subjective belief that authorities would be unwilling or unable to control a private persecutor, which is typical of domestic violence cases, is not sufficient for asylum eligibility, even when the country condition evidence supports the belief, if underlying events in the factual record do not support that conclusion. So this is looking at the fear of persecution from the objective side, and there wasn't enough evidence to establish an objective fear of persecution. And since I don't want to take a lot of time on these because there's a lot of material in here, I'm not going to discuss a lot of the details. So we'll just go to the next case, which is Ken LaFlack. I don't know. The names are difficult for me to pronounce, and you can read it. I'm not going to try to say it. In this case, the takeaway is that it is error as a matter of law to make an adverse credibility finding from evidence not submitted into the record during removal proceedings. And this was a favorable decision for the petitioner. What had happened in this case is that the immigration judge looked at an interview and a credible fear record that was never submitted into the record of the proceedings. And he waited he waited 3 months after the hearing to issue the written opinion, and there was not even mentioned in the opinion. It wasn't in the record, wasn't discussed, and then it was referred to in the opinion to support an adverse credibility finding. So the Fifth Circuit sent that one back. Okay, that was a remand. The next one is, yes, it's up on the board, Bertrand v. Garland. And I broke this up because there are a number of things to take away from this case. First, to justify an asylum claim where private actors are the alleged persecutors, the asylum applicant must show that the government condoned the private violence, or at least demonstrated a complete helplessness to protect the asylum applicant. That phrase, complete helplessness, was what was challenged in this case, but the Fifth Circuit says that that's good law. That phrase is not inconsistent with the statute. Second, despite the fact that Attorney General Garland on June 16, 2021 vacated the previous Attorney General decisions in matter of AB. And there was another AB decision by a acting Attorney General. The complete helplessness, unable to control standard is the same as complete helplessness. And that in spite of the vacation of matter of AB, the reasoning in matter of AB one, I think it was Attorney General Barr's decision, is good, is persuasive as far as the Fifth Circuit is concerned. It accurately interprets the statute. And you know, one thing to think about, you know, Attorney General Garland vacated some cases, but he didn't substitute it with any rationale. It just, so that left the field open for people to use any interpretation, including the reasoning in vacated cases to justify a decision. And if you remember, matter of RA, that was the late Attorney General, what's her name, Reno. She vacated that case in waiting for new regulations, which is the same reasoning that Garland, Attorney General Garland, vacated the cases that he did. And of course, we're still waiting for regulations for matter of RA. So I don't know if that approach is going to be very efficient, but nevertheless, it's being used again. And then the Fifth Circuit referred to matter of Shehu versus Gonzalez, which held that a government must condone persecution or demonstrate complete helplessness. Again, focusing on that phrase. Next case.
Simmer,
Yes.
before we go on.
Yeah.
How does this, because was this a DV, a domestic violence case? Do you remember?
Let's see. Which one are we talking about? The
Bertrand.
lane Bertrand? Bertrand was, let's see. I'll tell you in a minute. I haven't got to that one yet. Yeah, here it is. That was a Haitian citizen. No, it was a attack on his home. This was not a domestic violence case. All right. All right. Though it could be.
Right.
In some cases,
Yeah.
it would still apply.
Right. That's what I
Right.
was thinking.
Right. So the next one, Dudzi versus Garland. An adverse credibility determination must be based in specific and cogent reasons derived from the record. And an adverse credibility determination made without considering a claimant's corroborating evidence is not based on specific and cogent reasons based on the record. And then third, the Fifth Circuit Court of Appeals has never, they made, this is dicta, but they said in the decision that they've never held that demeanor alone supports an adverse credibility finding, where the agency failed to consider an asylee's corroborating evidence. Now that's kind of interesting because demeanor is mentioned in the Real ID Act. I mean, if you read the text, it says that a decision maker can rely on demeanor, but it's the Fifth Circuit noted that it's never alone been relied on. So that might be somewhere where we might get some leverage arguing against a adverse credibility finding. So the next one has to do, this is party Kumar versus Garland, and this has to do with the egregiousness. It boils down to that. They kind of went through a lot of parsing, I believe, in this case of using the substantial evidence rule and exhaustion of the issue before the board to determine whether they had jurisdiction or not. And it's actually an interesting case to read. It's long, and the Fifth Circuit gives you their reasoning for finding they don't have jurisdiction, and they finally boiled down to the substantial evidence on some of the substantive issues on the asylum case, and centering around egregious harm. And so in this case, using the substantial evidence rule, I said there's no evidence to compel the finding, a finding that the BIA decision could not be or the BIA decision was in error. In other words, there was no compelling evidence that would require a reasonable adjudicator to conclude otherwise. This involves beatings and threats, and which is described in the decision. And it also, the Fifth Circuit mentioned that the torture level for egregious harm is higher than the level required for persecution. That's something to keep in mind. The next one, Fabian v. Garland. And this case is another substantial evidence analysis. The substantial evidence supports an immigration judge's finding that an asylum applicant was the target of an extortion scheme who was targeted by the extortionist because she had owned a profitable business and not because she shared family membership with an individual who attacked and was beaten for refusing to carry contraband into a prison. So under the substantial evidence standard, and I think another panel might be dealing with this later on today, requires that factual findings are conclusive unless any reasonable adjudicator would be compelled to conclude the contrary. So that kind of summarizes the Fifth Circuit activity. There were two beneficial cases for the petitioner, and then the other three were adverse.
Judge Summer, and I know we talked about this yesterday when we were prepping for our panel, and I mentioned that I might ask you about domestic violence and there is the Fifth Circuit case of Jocko.
Right.
And can you talk just a little bit about that?
Well, you're talking about particular social groups, right?
Yes.
And to really understand this, I think you'd have it helps to go back to the old days before we had a particular and distinction if you go back to matter of Acosta before we had this more refined definition of a particular social group, all you needed was a common immutable characteristic. That gives this definition that the members of a particular social group must share a common immutable characteristic, which may be an innate one, such as sex, color, or kinship ties, or shared past experience, such as a former military leadership or land ownership, but must be one that the members of the group either cannot change or are not required to change because it is fundamental to their individual identities or consciences. Okay, so that's sort of the core of this. And then in another case after that was matter AME and JGU. This is in 2007, because this will give you a reference point. So a particular social group, according to the board, had to have some social visibility. And then there are other cases came, well, it's not actually physical or ocular visibility. It has to be something that is generally perceived about that group in society that makes it visible. And now we have, and it was in 214 where the board is still trying to define the same concept of social visibility when they talk about particularity and being socially distinct. It's really the same thing. They're just being more specific and detailed, trying to clarify it, though it may be not so clear the more you try to define it. At any rate, now we're dealing with, in addition to a common immutable characteristic, you have to have, the social group has to be defined by particularity and socially distinct. Well, particularity, sometimes you can meet that status like a family group, but I think what socially distinct means, even though you have this particular group that is unique, it's not recognized this is the ABI approach, which the Fifth Circuit takes. It's not perceived in general in society. It's like any other family, they're not anything distinct. So I think that an example of a family that the board gives in matter of LEA is the, that Tsar Nicholas II, his wife and family in Russia, after they abdicated the throne, they were politically a liability. And so the whole family was wiped out. And so that kind of a family unit would be, I think, clearly recognized as a particular social group. And you could draw a nexus between that and the harm that it experienced. And that's another thing about particular social groups is you can finally maybe define one, but then if you're not careful, you'll define a particular social group, but then you'll have trouble establishing a nexus between the harm that it suffers and the motive of the persecutor, which happens in a lot of these family cases. You say, oh, I got a particular group, it's particular, but it's not distinct in the sense of social visibility. If you think of these terms in terms of the old definition, you can kind of make sense of whether you agree with it or not. It's not so important, but if you understand it, you can formulate an approach to countering that. So that's why it's important to get a grasp on some of these concepts, which maybe you don't like, but at the same time, you have to understand them. And if you understand where the decision maker is coming from, then you can kind of anticipate and try to get into the record certain information that you can use to oppose that point of view or that interpretation. So that's why these old cases can be very helpful.
I think that was very helpful. And I think it's very helpful, especially when we have matter of WYC and HOB, which is the case that says you have to give the adjudicator, the judge, all your PSGs, right? And that also tells us, because I want to talk about very quickly, so I give Liz enough time to talk about other things about humanitarian asylum, because sometimes you're not going to have, you may have a judge who says, okay, you have past persecution, but it happened maybe a long time ago. And you've got two cases that are really important with humanitarian asylum. You have matter of Chen and you have matter of LS, okay? Matter of Chen was decided in 1989. Think about that, 1989. That was a long time ago, right? And matter of Chen was like, okay, you have such severe past persecution, and it was based on one of the enumerated 5 grounds, right? One of the enumerated, we already know that our political opinion, race, nationality, religion, and membership in a particular social group, right? So it was based on one of those. But what if the government says that there's changed circumstances? Then that's it, right? Or, and we talked about this also, right? They could say, okay, but there's no changed circumstances. Great, you get humanitarian asylum because it happened a long, long time ago. Okay. That's matter of 10, but matter of LS, they also talk about other serious harm. So what is other serious harm? The other serious harm may be unrelated to the past harm and does not need to be based on one of the enumerated grounds. So let's say you have that you've established the past persecution. Okay, and it just like matter of 10, you've established the past persecution. It's on one of the enumerated grounds, but you have changed circumstances. But you have other serious harm over here.
You know. I agree with that. There's something else. It doesn't necessarily have to be harm, I don't think. I think it just needs to be a very severe kind of a hardship situation. You could still grant it. It doesn't even have to be related to asylum. You know, it could be almost any, like this person, let's say they cut off his tongue or something, and now they're going to send them back. You're going to look at these same people. I mean, that is too much. It's not going to happen. You know,
Right.
A decision maker could reason that way.
So that's matter of LS. So think about that. So in some of the DV cases, you want to look at that, okay? And look at matter of LS. And think about how you can use your humanitarian asylum in some of these cases. And look at other serious harm. Because you also have to look at because the matter of LS also talks about reasonable possibility, right? And they talk about, look at this, is there civil strife? Is there extreme economic deprivation? They look at all of this stuff, exactly what Jed Zimmer just talked about. So kind of think outside the box. And this is kind of where you're going to start looking outside the box because you're going to be advocating for your clients. So I wanted to give some time to Liz. So Liz.
Hi, everybody. So a couple of things before I jump in. First, I'd like to say thank you to the University of Houston Law Center for inviting me again to participate. U of H Law Center is my alma mater. And Judge Vail was a dear friend. And so it's an honor and a privilege for me to be invited and to participate. So thank you very much. And secondly, I would like to thank U of H's Immigration Clinic because the clinic has taken some Afghan cases. And I'm extremely profoundly grateful and want to shout out right now to Lucas Eisenberg and Rosemary Vega. For and their students whose names I can't remember, but I'm sorry. They know who they are, you all know who they are. But Rosemary and Lucas know that I've been working for about a little over a year now with an Afghan community that I've adopted, and the clinic took some cases and they've done excellent work. And I just wanted to say on behalf of that community, thank you so very, very much. And my last thanks is to all of you. If you're here, you have some modicum of interest in repping somebody in an asylum case, my hat is off to you. It is not easy. It can be some of the most enriching for your soul work that you will ever do. And so it can also be soul crushing. But thank you for being here and your interest in asylum. It is tough. You can read the stats. Close to 90% of people who apply for asylum don't get a grant. And we're in Houston. So look at the numbers. Our stats are not very favorable, unfortunately. But it's a worthy cause. And so I'm really, really, really happy to see that so many people are here participating. So let me jump into what I wanted to address, which is famous / infamous scheduling orders. So What the heck is a scheduling order? It is the bane of my existence. So when the pandemic broke out and we weren't going to court, basically, and you know, to an extent, I think this makes an awful lot of sense. EOIR said, hey, why drag you to court for a 5-minute master calendar hearing, do in writing what you were going to do in person in a hearing? And so, you know, ergo, the creation of scheduling orders. So typically there are 2 to 3 scheduling orders in the life of a removal case. The first one is going to ask you to plead, to submit pleadings. The second scheduling order is going to ask you to submit a relief application. And the third scheduling order is going to be focused on getting your case trial ready. All your SUPDOC, all your statements, all of your, you know, whatever it is, the A to the Z that you need to sup that case. Scheduling order number 3 is going to tell you do A, B, and C by these dates. So for the purposes of what we're talking about today, our panel in this workshop, we're talking about Asylum. What do you do with the scheduling order number 2 that tells you to submit your relief apps and all evidence of prima facie eligibility? What does that mean? What does that mean that you're supposed to submit evidence that your case, that your client is prima facie eligible for asylum? And so the problem is that you can talk to 10 different people and get 10 different answers. So I will share with you what I do, which as of now, knock on wood, I haven't had an issue. I am filing the I-589. I am trying to flesh out as much as I can my answers to the questions. I may not necessarily submit a declaration because that's what the continuation pages to the form are for, in my opinion, which my client is signing under penalty of perjury. I don't know why judges ask you to submit a declaration when I already declared in the I-589 under penalty of perjury. So anyway, so the form, flesh out your answers, okay? Identity documents. I really don't submit an awful lot more than that because I know I'm getting scheduling order number 3, which is going to tell me to submit a mountain of evidence in support of the app. But you have to overcome this initial hump of, okay, is there something there? Is there something there that is just slap your face? This is super obvious. Okay, we have some, you know, indicia of a claim. An arguable claim. This is not a frivolous claim. Other people think that you might need to submit a lot more supplemental documentation with that initial relief application. I really haven't been doing that. I haven't had an issue yet. Hopefully I won't. And you know, something that we were discussing yesterday in our prep for today's panel is, okay, well, what about, you know, if your claim is based on a PSG? You know, do you have to flesh out the PSGs in your application? I'm not going to flesh out the PSGs in my application. I don't have to do that. The judge is going to order me to do that. I have to comply with WICHOP, and I'm going to comply. At some point, the judge is going to get in writing what my PSGs are. I'm obviously going to state, you know, I'm going to craft in some manner, well, you know, she is a journalist. He's gay. She's an ex-police officer, but I don't think I'm necessarily going to put in my I-589 the 4, the 5, the 6 PSGs that I think may apply to my client. That's going to come down the road. So when you get a scheduling order asking you to submit your relief application, asylum, which we're talking about today, and you've got to submit prima facie eligibility, keep in mind there might be a fine line between how much do you have to give, what is really, you know, baseline necessary. I haven't gotten feedback. I'm a member of AILA. I'm the AILA. Rosemary and I are co-liaisons to EOIR. I really haven't gotten a lot of feedback from many members saying, "Oh my God, my I-589 was, you know, pre-terminated because I didn't submit anything regarding prima facie eligibility." I haven't submitted that.
Liz, real quick, with the unaccompanied minors, the UCs, I always, with the written pleadings, I always make sure that I make my argument that this is a UC. I make my JOP argument, And I also include that same argument with the I-589 just to cover myself, but
And also, you know, if you have anything regarding a 1-year deadline issue, you might want to raise that. You know, there's a question about, you know, are you filing this before, you know, within a year? And if that's something that you think you need to address, you know, you might want to put a blurb in there in your I-589 about that to preserve it. So we're almost out of time, apparently, so I'm gonna try and wrap it up, and I'm gonna just say this. Our private bar here in Houston in my opinion, we're a good bar, we're a collegial bar. Most of us are. And so if you find yourself needing mentorship, you know, reach out. I know that Rosemary and I would be more than happy to mentor, just like people mentored us, starting with Professor Joseph Vail, who, you know, this workshop is named in his honor. So you can find me in Google, send me an email, call me if you have questions, if you need to bounce something off of somebody, I'm more than happy to help however I can. So thank you very much.
Yeah. What, I'm gonna try to fit in something real quick. Liz said about PSGs, you know, is submitting it as a part of your prima facie case. I think it would be error for the judge to deny a case on a PS just because the PSG does not line up with or align with a case law. And the reason is you have to remember the question of a PSG is a mixed question of law and fact. So if you're going to jump the gun before you allow any facts to be submitted in the record and deny it on case law, and no case law has ever said that any of these PSGs are on their face necessarily without fleshing out the facts. I think it's a procedural error, and I think that's another argument you might be able to make on appeal if that happens to you. Something I want to throw out there.
Panels, under 45 minutes of presentation, the last 2 minutes are reserved for questions. So we have about 5 minutes left with you all to be able to any audience questions. Just please go ahead, feel free to raise your hand and ask questions to our family.
Don't be shy. Yes.
General question about scheduling orders. Scheduling order, I get a lot of. They're taking off the calendar. There's no final hearing date given, and then they ask you to present all documents for all. So if you do a final hearing date, and then they give a final hearing date months later. What are you doing as far as presenting additional evidence? Because new evidence comes up, obviously you can't get everything in advance. So are you filing a motion?
Yes.
Like filing?
Yes.
All?
Yes. So did everybody hear this gentleman's question? Okay. So the gentleman over here asked, hey, we get a scheduling order telling us file everything in the next, for example, 60 days, but then your individual hearing is, a year later. And so what do you do when you want to update the record and submit, recent fresh evidence? And the gentleman asked, are you filing a motion? And my answer is yes. So, a consequence of the creation of scheduling orders is that your motion practice goes through the roof. And so, yes, I'm having to file motions to accept all the time. Because if I'm in a hearing today and the judge is telling me, okay, Ms. Melissa, I want you to file everything by March 1 of this year, everything, but I'm booking you for an individual in November 2024, I know sometime in 2024, I've got to file another packet of SEPDOC with the motion to accept. It sucks, but that's where we're at. So, yeah. Or, you're going to file a motion to extend your deadline to file the evidence. The information that I've gotten or the feedback I've gotten from EOIR is that the judges have to do everything they can to make cases trial ready. Why some people ask to submit everything in 60 days, but then they're going to book you a year or two out, knowing that you're going to have to sup it. I don't know, but yes, it's a lot of motion practice, unfortunately.
Maybe,
Maybe one of the judges in the panel can enlighten us about that.
well, you know, maybe, yeah, I mean, I never did that. I just went by the policy manual. So you gotta submit your evidence 30 days before the hearing. I mean, that's really much. And actually, you can make that argument, well, yeah, I already did what you told me to. This is my evidence. I met that requirement. Now, this is just simply a new evidence that I want to submit that supports my.
Oh,
So, you know, as long as it's timely, within 30 days of the hearing, I don't know why you wouldn't, unless the judge is so specific and said, I'm not going to take any other evidence at any other time, but I don't think that's reasonable.
Well, and I will say this, I mean, to date, I haven't had any of my motions denied.
Right.
So, you know, to submit, so hopefully I'm not gonna have any.
And something that I wanted to say about scheduling orders is the judges are all over the place on the scheduling orders. You know, some judges are taking the hearing off the docket altogether and saying, okay, file everything by this date. And then when we get everything, we'll schedule your hearing. And then others I have, okay, we're gonna schedule you a final hearing on this date and I want everything filed 30 days before the final hearing date. And so they're all over the place.
In defense of the judges who asked for documents within 60 days and the marriage hearing hasn't been scheduled. There's been a lot of additional judges added to the Houston area. So the judge who hears that case on the master or for the scheduling order may not be the judge who hears it on the merits. It may happen a whole lot faster than a couple of years from now. So that's one reason that they do it that I can understand.
One more thing that I want to throw out there that's a little outside of the scope of the panel, but especially for those of you who don't do a lot of asylum and you're just kind of getting into it and you're really, really interested in this, just heads up. You know, you submit like the world's best application, you work your butt off. I mean, you know, supping this case, it's just like beautiful, beautiful, beautiful. And you show up for your individual and OPLA moves to dismiss your case. Can you object to that? Absolutely. And if the judge dismisses anyway, can you appeal? Yes, you can. So just heads up, that could happen to you. Try to reach out to OPLA ahead of time and talk to them. Unfortunately, a lot of times OPLA is not touching your case until 5 minutes before the hearing. I'm exaggerating, but not too much. So try to reach out to them before and see if there's anything that you can flesh out, but that's happening quite a bit.
I think we had a question right here.
I told him on Sunday, the policy man, I would think this is this is what I've done, you know, like I've applied to over the best I can, and I speak for like how available, but I have not found a motion to provide because I was under the impression that the policy man will, you know, say, hey, you have 30 days.
It's their court. They get to call the shot.
Yeah, as a disclaimer saying that the immigration judge can change that.
Yeah, yeah, they do have that discretion, but if it's not clear, I mean, I think you can say this is not related to that first submission. This is just additional evidence. And it's coming in 30 days before the hearing. Unless the judge just said very, you know, absolutely that I'm not going to take any more evidence, which I don't think anybody would do it because you don't know what could come in and might do something, and you haven't even had the hearing yet. So I don't know, why you would.
Also, I mean, for the, it's not available, but some of the last filing, it's not, you know, let. It's trying to put whatever, you know.
Body emotion.
To point to great, great advice, I wish I was wondering how did that work with the 30-day deadline.
To play it safe, I would file a motion.
I mean, you
Yeah,
so sometimes in situations where you're moving to, you're moving to enter evidence the day of your hearing.
Yeah,
You got something the night before. So.
we've
So, all
told,
right, we gotta stop.
we're done.
Round of applause.
Thank you.
So today's panel is the affirmative asylum and UAC panel, which is the unaccompanied child panel. So we're going to begin by asking some questions and we will speak for 45 minutes and then afterwards y'all can ask us questions. So. So first question is for Samantha. From what countries is USCIS receiving the most asylum applications?
So I'll answer that, but first I really wanted to acknowledge the fact that we're here today in a workshop named after Vail, who was my and Dalia's mentor. Actually, we both were in this clinic, well, the old buildings clinic, about 15 years ago, which is a really long time and it's hard to believe. So it really is an honor for us to be here. And to see so many people interested in immigration law and particularly in asylum. So with regards to countries, this year, there's been a big shift recently. And nationally, Cuba is #1. We're receiving more application, affirmative. So mind you, we're talking about people who either enter with some status or are here undetected. We're not talking about EOIR. The numbers are very different, look very different for EOIR. But for affirmative asylum, Cuba's #1, then we have Venezuela, and then Afghanistan. Those are the top 3 countries. If I'll give you some resources later on how to find these numbers, but in the top 20 countries, we have the Golden Triangle, obviously, China, Mexico, and then some more surprising, or at least to me, like Armenia, Uzbekistan. Those are the top 20 countries. In Houston, we track very much the same as nationally, with a couple of exceptions. So I printed, here we go, some statistics. So in Houston, we have, let's see, we have, here we go. #1 is Venezuela, and then Cuba, and then Afghanistan. So we have kind of the same. And then our next few ones, this is where the biggest difference is, are from the Golden Triangle. And nationally, it's different. Nationally, it's Haiti, Colombia, Nicaragua, but we have a lot more Central Americans. So that's how we track. About 99% of the Afghanis were granted asylum, and that tracks also in Houston. And then, let's see. And the biggest caseload in Houston that they're actually working on is Afghanis. So not necessarily in receipts, although it is actually in receipts for the past 3 months, but it's Afghanis that they're scheduling because they're given priority because of the Operation Allies Welcome is the name of the operation, and they'll go by OAW. And these numbers, they're brand new. They're the numbers for the last 3 months of last year. They just came out yesterday, so they're really new and fresh.
And how long are the backlogs right now?
Okay, so the backlogs, that's the big, the big issue, right? We don't have any local statistics, right? But nationally, we know that the backlog grew in 2022. They received over 200,000 applications on paper. But because there were so many pending that have not been receipted yet, and that's another problem that we'll discuss in a minute, they estimate that for the entire year, we'll probably have about 600,000 to 615,000 receipts, right? So that's how many have been received. And that's due grossly to Cuban and Venezuelan in receipts, right? They've increased, Cubans have increased by 1,500%. We used to get about 9,000 applications a year, and this year was 35,000 applications for Cubans. And then Venezuelans also grew by 280%. So those are the latest statistics. And then, of course, the asylum offices have been taxed by CFIs and RFIs, MPP, and then, of course, MPP, I mean Migrant Protection Program, the people who had to remain in Mexico. And then the new regulations, the asylum merits interviews, which I'll talk about in a minute. So all these things have contributed to growing the backlog. So what we have right now in terms of numbers for the backlog, nationally, it is, get ready. Nationally, we have, sorry, it's on my last page. 607,000 pending. Right. So those are the ones that were just kind of hanging out in the backlog. In Houston, we don't have a number, but what I was able to get from them when I spoke to them yesterday is that it has grown. And last time we had a number from the asylum office in Houston, which was a couple of years ago at this point, it was about 60K. So it has grown, that's what we know. So we know that in Houston only, there are more than 60,000 cases that are pending.
Just a follow-up question. So do you know what USCIS is doing in response to the backlog?
So they're doing actually a lot. I mean, it's surprising, but and it happens a lot in the background. So it's difficult to see. We don't necessarily see a lot of asylum interviews scheduled. You may have seen some. Anybody in this room has seen asylum interviews for old cases scheduled in the past 6 months? 1, 2, okay, 3, 4. Okay, great. So what's happening is that, so the first thing is that they're still doing last in, first out. They're still committed to it. They love it. And the reason is that it reduces the number of people who apply. That is at least what their statistics are saying. So they're committed to last in, first out. So for those of you who are not familiar with it, the asylum office is used to process applications in the order that they were received, just sort of like a normal process, right? But in 2018, they changed that rule so that the last application received would be the first one to be interviewed. And that added to the already existing backlog. So that means that if you file today, you should have an interview earlier than my friend who filed yesterday, right? The idea is to expedite these interviews so that people are not tempted to file an asylum application just to be eligible for an EAD, a work permit 6 months later, right? So that's the idea. So they're remaining steadfast on these priorities. But first, they've hired a new senior advisor to coordinate backlog reduction at headquarters. So since July 2022, she's been working on reducing the backlog. And then the next thing that happened is that they got some congressional funding to fund special positions to reduce the backlog. So now remember that the asylum office is under USCIS, and USCIS is not congressionally funding. They're entirely fee funded, right? So this is a special appropriation by Congress to hire dedicated asylum officer and other positions so that they can reduce the backlog. Nationally, there's 152 positions. They're not all asylum officers, a lot of admin support there, but about 65% were already hired as of December. So that's what they're doing. In Houston, they have a few of these positions already filled. I don't know how many, they weren't able to tell me. And then different offices will have different numbers of position depending on need. So in the last 6 months, that's why you might have seen some old cases scheduled. It's not because they're getting through the backlog through any other means, right? It's not because they're getting less receipts or really tackling it in a normal way. This is a special appropriations. Generally, the asylum offices are also hiring. They keep hiring more and more people. There's about the staff of the asylum division today is about 2,100 more or less people. They're almost fully staffed at about 80%. They were hoping at the last stakeholder meeting in December, they were hoping to get to 95% by December 31st. I don't know if they got there. Those numbers are not published yet. They're also ramping up circuit rides and training for asylum officers. They're building new asylum offices. Here in Texas, we're supposed to get one in San Antonio and one in Dallas. So that's really, really exciting. I don't know if there'll be offices of their own rights or if there will be just space for the asylum office in Houston to do interviews. I don't know yet. But that will be interesting and definitely will be much easier for people who don't live in Houston, because Houston, the asylum office in Houston covers a huge area. It covers all the way to Utah and all the way to Tennessee. So it's a huge area that it covers.
Just to jump in.
Yeah.
And give an example for the audience. I'm based out of Denver now, and my affirmative asylum cases go through ZHO.
Yeah.
So yeah,
That's
for the
right.
Houston office.
Yeah. And Denver used to have circuit rides pretty regularly, but since COVID-19, there has been no circuit rides. Is that correct?
I think they were able to get there a few months back for the first one in a long time.
Yeah, I
But
think
they
had
got
an
through
access,
just some
yeah.
old cases that have been waiting forever.
Yeah. So if you live, in one of those places that are far from Houston, it's been extremely difficult, even more difficult than here for the past few years. So I think people have a choice to travel if they want to, but it's obviously a huge hardship for people to travel from Colorado or Utah all the way to Houston. And then the last thing that they are doing is they're digitalizing files, which is super exciting. There is a new way to file online, but it's not just that. They're also going through old file and making them digital, which should increase efficiency. And that's going to be, that would be so much nicer to be able to access that online and have some more, online access. And I think that's it. Oh, there's a new backlog page that is supposed to be launched. The last time I checked, it hadn't been launched yet, but maybe it is now. I'm not too sure. I forgot to check again.
Okay. So I'm going to ask some questions to Dahlia about UAC. So who is considered an unaccompanied child?
Good afternoon, everyone. It's a pleasure to be here. I echo Samantha's sentiments and just what an honor it is to be with you all today. So an unaccompanied child was first defined in the Homeland Security Act of 2002, and you can find it at 6 USC 279 G2. And basically, it describes somebody who is under 18 years of age with no lawful immigration status and no parent or legal guardian in the US available to provide care and physical custody. Now, the reality is that a UC determination is made at a single point in time. And so for the most part, that's going to be at the border. So if a child enters the US without a parent or a legal guardian, and they're apprehended by a Customs and Border Protection agent, then they're going to be deemed to be an unaccompanied child. And this brings about certain important protections. They have to be transferred to the custody of the Office of Refugee Resettlement within 72 hours. They're placed in removal proceedings. That's a huge benefit because, as we know, other people might be subject to expedited removal. And they also get some additional asylum protections. Now, this covers kids from non-contiguous countries. So children from contiguous countries, which, we know that this is going to apply mostly to Mexican children. They're treated a bit differently. They're actually allowed to withdraw their application for admission unless there's an indicia of trafficking. There's some indicia of trafficking, or the child expresses a fear of returning because of a credible fear of persecution, or if the child can't make an independent decision to withdraw their application for admission.
Okay. As a follow-up, how is asylum for a UAC distinct from adult affirmative asylum cases?
So the Trafficking Victims Protection Reauthorization Act, the TVPRA of 2008, actually changed the INA in several ways to give some additional protections to unaccompanied children that are going to be seeking asylum. So first of all, they're exempt from the safe third country exception that's found in the INA. They also are exempt from the 1-year filing deadline, which is a huge plus. And then it also gives USCIS initial jurisdiction over the asylum application, even though most unaccompanied children are going to be in removal proceedings. So, unlike all other applicants, if you're in removal proceedings, you have to, have your case adjudicated by the immigration judge. For unaccompanied children, despite the fact that they're in removal proceedings, they get to go to the asylum office to have their case heard. And this is, in recognition of their status as a child, and, being put in a non-adversarial setting is a benefit to them.
From Title 42 as well, not TDRA.
From title, yes, I think Judge Benton mentioned that unaccompanied children aren't subject to Title 42. They were initially for the first 6 months of Title 42, but there was some federal litigation which stopped that practice. And then when the Biden administration came in, they were officially exempted from that.
So I'm gonna hop over to Brandon, and I'm gonna ask him a question not related to UACs, but adult affirmative asylum cases. How do you typically handle affirmative asylum cases in your practice?
Well, there's no such thing as typical with anything, right? So I'm in private practice now, although I worked for years with under Dahlia at SELA and with the unaccompanied children throughout Houston and Texas. But I've been in private practice now since 2018. Based out of Denver, but most of my cases are still in Texas or anywhere in the country, really. So affirmative asylum for me, obviously you're doing the consult with an eye on, is this a valid claim? And doing it all over the country, first thing I look at is what circuit are we going to be in for this, right? So I'm thinking in the back of my mind about the pros and cons of the case, but also trying to keep in mind, obviously I don't know the circuit law in every single region. I'm not even going to claim to be that good of a lawyer, but I know enough to know where you start blurring the lines. That for me is, know when you're going to get close. Okay, I know there's something in the Third Circuit about this. I'm probably going to want to look it up later, but just to know kind of where you are. Obviously, the Fifth Circuit is one of the harder ones to practice asylum law in. I say obviously, but I think that's pretty obvious, right? So, knowing those kind of things, and then I'm looking for what are the timelines for an interview and a decision in those different places. I know generally Houston the best, and kind of, okay, if we file, this is going to go under LIFO, the last in, first out. So it's going to be quick. There's some, regions that are faster than others, of course. So knowing the timeline, because in some cases, your goal is maybe to, not file a frivolous claim, but at the same time, lose slowly to do the best thing you can for your client, to fight the hardest fight you can. But in the end, it's probably not, super strong. You want to at least be able to give them the best advice possible and make it, give them the information about making an informed decision. Is this worth it for me? Is this worth the money, the time, the anguish that I might have to go through to rehash these things, given the circumstances and the odds in a given place?
And Brandon, as a follow-up, what resources do you use when preparing an asylum application?
So, country conditions reports and things like that is what I'm assuming we're getting at here. The types of evidence that I would file, country condition reports are going to be pretty, the first part of them pretty standard. So State Department reports on the particular country in question, Human Rights Watch, Amnesty International, they all have great, very thorough, and usually it's updated every year, if not every other year for each organization, on the country conditions on the ground there. You want to educate the judge, or in this case, an affirmative decision, the asylum officer, about that country's conditions. I don't always, with an affirmative case, put the entire report in. If it's a State Department report, especially, the officers are well trained enough to at least, be familiar with the countries that they're interviewing for. I would much rather be before an immigration asylum officer than a judge, because judges see people from all over the world, right? And you can't be an expert in everything. With the officers I've seen, they have a little bit more awareness of different countries. So I'll just submit certain segments of the report that are very, relevant to my client's case. Other things I look for: media research, of course, anything that's been in the press. I can research English and Spanish language media, but I'm not, going to be able to research something in Kazakh. So I will have my clients give them homework. Hey, if there's anything about your case or about the people involved that maybe persecuted you in your local press, I need you to look that up and get it to me, and we'll get it translated and we'll get it, into evidence. But I can't do that. We can't pay an interpreter or translator to just scroll the internet looking for, media on point. Other things that I look for are congressional bills or testimony. There's a lot of stuff, about human rights situations around the world. Usually that comes to my attention in a media press article, but rather than just submit the article, which I'll also do, go find the actual congressional record of the testimony of whatever expert was testifying before that particular subcommittee, that month, talking about that country and that particular religious persecution, Coptic Christians in Egypt or whatever it might be. And I find that to be hopefully pretty persuasive. You never know what actually is persuasive in the end, but I like to do, I guess, primary evidence.
And we do have a handout that we shared with everybody that has some additional resources. The Center for Gender and Refugee Studies has a technical assistance program, so you can seek their technical assistance and you'll get country conditions reports. They also have an expert database. And there's a new project, I think it's Temple Law and WOLA. They have some country conditions indexes as well.
And this is a question for Brandon, but also for everybody. Are there certain types of books or websites that you go to first when you're preparing your asylum application?
I mean, besides Kurzben's, I don't.
Yeah, so Kurzben.
That's obviously a primary resource. It depends on the country, I guess. With Central American cases, I've done enough of them over the years where I have a pretty thorough kind of resource library of different things that I would use in those, and then I would just want to update it or make it specific to my client's circumstances. The Ayla Asylum book by Dree Colopy. I don't know the name of that.
Asylum
Primer. There we go. That one I love. Yeah.
And that one you can get access to through Ayla link. And I know not everybody has access to that, but if you go to the Texas State Law Library, you can get a free membership and they have access to Ayla link. So one way to get access to those resources.
One thing I'll add for private practitioners is, over the years, I've kept like a PSG kind of folder, right? And every type of PSG, and then I also cross-reference that with different country folders for country conditions. So, if I did a case out of Kazakhstan 2 years ago, I can pull that up, of course, as a starting point for my country research and then update it. But also for PSGs, same thing, like very specific PSG folders of all the different conditions and reports that you use there. Because even if it's not that exact country, it could still be very relevant for your client's case, an El Salvador case, but you're now doing a Guatemalan case, you can still use it.
Dahlia, are there any websites or books you would recommend for asylum?
I think just going back to the Ayla link website and to the other resources we've mentioned. I don't know if Samantha has any additional ones that she looks at.
I do like the ILRC manual for kind of a quick reference.
And what does that stand for?
It's the Immigrant Legal Resource Center. They're in California. They published all kinds of manuals. The Asylum is probably not their best manual, but it is not bad at all. And it has really quick references and it has indexes with examples. So that's really useful. And then it might sound really basic, but I always go to the USCIS webpage and make sure that I have the right I-589 because they get updated, right? So if you did your last asylum case a year ago or so, you want to go back and double check. And the instructions, right? I always want to make sure that they don't update the instructions on how many copies or anything like that, that the last thing you want to do is get your asylum application rejected because you put, one copy instead of two, or the picture of the wrong kid on the wrong page, whatever the case, right? This happens a lot, so.
Also, if you're doing a case for a minor under 18, check out CELA's website. They got great resources.
That's right.
Yes, I use that like a lot. That's how I met Dahlia, actually. I kept peppering her with questions about SIJ. So I want to go back to Dahlia, actually. What happens when the UACs become adults?
So There is a policy that was issued by USCIS. It's called the Kim Memo, and that came out in 2013. And, it says basically that once another agency has made a determination about UC status, then the asylum office is going to abide by that determination. Before the Kim Memo, the asylum office was really looking at whether or not the child had been unaccompanied at the time that they filed their application. And I went to a couple of asylum interviews, back during that time, where the asylum officer would sort of have these pre-interview questions and ask the child things like, would assess whether or not they were 18 at the time they filed, and have all these questions about, reunification status, whether they had, reunified with a parent. And the Kim Memo stopped all that in 2013. They realized that they were kind of wasting resources and making this additional determination. And so they accepted, it was more like a tattoo rather than a stamp. If a child had already been designated unaccompanied, then they would take that designation and make a determination about the asylum application. During the Trump administration, they decided that they didn't want to follow that memo any longer. And so there was a new memo in 2019 called the Lafferty Memo. And that attempted to reverse this policy, instead allowing USCIS to make that determination about UC status at the time of filing. But thankfully, there was federal litigation on that. And so that policy was enjoined in a class action lawsuit called JOP v. DHS that Rosemary mentioned in her last panel. And so basically the injunction in that case retracted the Lafferty Memo, so that's no longer good policy, and reinstated the Kim Memo. Importantly, it prohibits USCIS from deferring to the immigration court about a UC status redetermination, and it enjoins ICE from opposing any continuance or taking the position that USCIS does not have initial jurisdiction. So if you are in immigration court and the ICE attorney is trying to argue that your client is no longer unaccompanied because they turned 18 or because they reunified with a parent, for example, then they are violating the permanent injunction in this lawsuit. And you can contact the class counsel on that. So the question was, what happens when they turn 18? This is the USCIS policy. They're taking jurisdiction even if a child turns 18. Unfortunately, there is a case, and I know this is the affirmative asylum panel, but we're going to talk about immigration court. So there is a case called Matter of MACO. This is a BIA case, Matter of MACO. And in this case, the BIA concluded that the TVPRA asylum provision doesn't prevent the immigration judge from determining whether initial jurisdiction over an application filed by somebody who's turned over 18 lies with the immigration judge or USCIS. So this case allows the immigration judge to make that determination about whether or not the child is unaccompanied. And so if the immigration judge wants to, they can take jurisdiction over the application if the application wasn't filed, prior to the child turning 18. Importantly, the immigration judge doesn't have to take initial jurisdiction, so they can allow USCIS to make that first determination. What we recommend is that if at all possible, file the asylum application before the child turns 18. If that is not possible, try to file the asylum application before you get to the immigration court so that you can, let the judge know this is an unaccompanied child that I've already filed with the asylum office. But if the judge wants to make that redetermination, you can ask for an evidentiary hearing and force the judge to make that very fact-specific determination. One of the things that comes up if the immigration judge is going to take jurisdiction is the one-year filing deadline, which, is exempt for unaccompanied children, but not for other applicants. There is a helpful unpublished BIA case called Matter of AD that has some arguments that you can make to claim extraordinary circumstances for young adults.
Related to that, is there anything that the UAC would do to lose their status?
So the USCIS Kim memo does say that, you know, the asylum office is going to take jurisdiction as long as there was no affirmative act by HHS, ICE, or CBP to terminate UC status. The only example that I know of that is found in the Affirmative Asylum Procedures Manual. The asylum office says that if a child is in the custody of or in the care of the Office of Refugee Resettlement and ages out and is transferred to an ICE detention facility, then that could be termination of status. Although, you know, that's just in this policy or procedures manual. That's one example. The other possibility is that somebody could try, an immigration judge could try to redetermine status because they've reunified with a parent or a legal guardian. Matter of MACO, which I just talked about, does not get into that at all. They actually say, the BIA actually says in a footnote that, you know, the immigration judge didn't look at reunification status in the case. And so there's no appellate, there's not enough in the record to make a decision, to allow for appellate review. So that issue is still undecided. I know that some immigration judges will look at that, will look at reunification status, but again, you know, I think this is a fact-intensive determination, and so you should ask for evidentiary hearing to see, whether the caregiver is actually available to provide adequate care at the time of filing, right?
Thank you. My next question is for Samantha. Going back to when you're talking about the backlog related to that, what is USCIS going to do about the long wait before applicants receive their receipt notices?
So that's not in the purview of the asylum office. Unfortunately, it's the service centers, right? So there's a couple of things that may help reducing. So first, they acknowledge that, right? In the last stakeholder meeting in December, they acknowledged that there is a problem with issuing receipts. And that number will grow because they are implementing the electronic filing. And I think that's sort of growing pains there where they're having trouble, or they're allocating more resources to the electronic filing than the paper filing. So it will grow. I think the couple of things that are going to alleviate this, one is, the electronification of everything, that should really help. They're also moving the filing from the service center to lock boxes, which should increase efficiency. And then finally, my recommendation here is if you can file online, because they have said that if you file electronically, you will get a receipt notice much faster. So, I have not filed one electronically yet, but I have heard anecdotally that it is true. People do receive receipt notices faster. So that's my recommendation. That's kind of all they have in the works right now.
Related to that, what about the individuals who are asylum seekers and they filed their receipt notices and they want to apply for employment authorization? What can they do about that?
So if you don't have a receipt notice when you're up for an employment authorization, so 150 days later, the first thing is doing service requests with wherever you filed, right? At this point, you may have filed electronically and hopefully you have a receipt. You may have filed with the service center, or you may have filed with the lockbox. I think the lockboxes I think they are now the places to file. But so if you have filed with a service center, it would be the Texas Service Center, unless you filed your UC application. But that's who you have to contact. Make sure that you send your asylum application with a tracking number so you can provide that tracking number and when it was delivered, potentially even who signed, and they will look for it. And that has happened, and issue a notice if they find it. Otherwise, you can try to file your EAD application and, with supporting documentation, the copy of your mailing receipt, etc. there's no guarantee that it will work. If it's not in the system, it's not in the system. So in other words, if it's been already entered in the system, but it's just a receipt notice that's missing, you have a chance of getting your application processed. But if the problem is not that the asylum application has not been entered in the system, then there's no way for USCIS to verify you filed one, and you're just out of luck, really.
Thank you. My next question is for Brandon. So for when you're preparing an asylum application, do you prepare a bare bones application or a very detailed asylum application? And if so, why?
Depends on the case. Usually time is the primary factor there. Obviously, if somebody walks into your office the week before their 1-year deadline, you're not going to have time to prepare a detailed asylum application. You want to get something in and then supplement it down the road, with whatever you can. But at least that way you get it in and avoid that circumstance where they go beyond 1 year. Detailed even, it depends. I mean, detailed in the sense of providing as much as they have at the time, of course, if I have time to do it. But from a brief standpoint, I probably, in most cases, wouldn't do a full legal brief for an affirmative case. I would probably do what I call a thorough cover letter, like a 6-page cover letter that is really a brief kind of tucked in there. Just because in my experience, or in my opinion, I guess, it doesn't get read. If you submit a 25-page brief to the asylum office, and I mean, in my opinion as well, it might not get read if you submit it to court either, but you're doing it there to preserve the appeal. With the affirmative asylum office, I'm doing it because I want it to get read. I want the officer to be as familiar with the case as possible when we walk in that door. And so I've always gone by that maxim of, kind of less is more in that sense.
Related to that, one of the things I wonder what you do is, do you include a detailed affidavit or declaration for the applicant?
In most cases, yes. It depends on the applicant, in my opinion. If they are, because a detailed declaration is great if you know that that client can then testify exactly along those lines as well. And that doesn't mean that it's not true what they're saying, but if their ability to recall information, whether due to the trauma of the situation or just due to their own memory, if that's in question, then I might not want to put as many details because I don't want the officer to get hung up on whether the assailant's shirt was red or blue that day. I want them to focus on the assault or whatever it was. So I guess, it depends on how well I think my client's going to testify in that regard.
And how do you typically prepare your clients for asylum interviews?
So I wouldn't start prepping them for an asylum interview until about 2 months before the interview. Now, obviously, at that point, we've already met several times. We've gone through the case. We've filed. We will have probably done a detailed affidavit at that point to be submitted. But as far as actual interview prep, I would start about 2 months out. I would do, just a full interview session where we go through every piece of evidence that we filed or are going to file. So the client knows everything that's on the record for them, kind of refreshing their memory because it may have been years, 10 years or more in some cases, since the actual events have occurred. And so refreshing their memory, that's probably like a 2-hour session, just going through everything that's going to be in the record, practicing which kind of questions they're going to get. The next session, or maybe I break that into 2 if it's a particularly traumatic kind of session, but the next discrete session that we'll undertake is going to be what I call the woodshedding. And I'm going to tip my hat to Bob Etnier and his amazing article from several years ago on how to prepare an asylum case. And that's available, I want to say, on SELA's website. I know that's where we used to have it up there somewhere.
Yeah, I don't
But-
think it's there, but
okay.
it's a great article.
Bob Etnier wrote this article, but he calls it woodshedding. And that's essentially getting your clients ready for cross. Even though there's not going to be cross in an affirmative interview, the officer is essentially cross-examining your client in some respects. So I want to point out the weaknesses of their case. I want them to see what makes total sense to them and why I absolutely know that that's what happened, why it might not make sense to an American asylum officer in an office setting who's never been to their country or never seen whatever they saw. So I do that session specifically to woodshed the client to kind of get them used to what it's going to be like under a rough cross-examination. And then after that, the next probably 2 sessions are like what I would call the pep rally sessions. build them back up. I pointed out all the weaknesses, why their case is going to get, destroyed by this officer. And now I want to start pointing out, okay, but here's the things that are good. Here's what's going in our favor. Let's focus on this. I want you to practice that piece again, because I want you to make sure you're getting it right, especially according to your affidavit. So kind of a pep rally, build back up their confidence while you're working on their actual testimony.
Thank you. Going back to Dahlia, talking about UACs. What happens to UACs if their asylum case is referred to immigration court?
So, once the asylum office has heard the case, then, they could either grant asylum or refer the case back to the immigration court. So if it's referred, then obviously it's going to get reheard by the immigration judge, and they'll be able to make a determination about whether or not to grant asylum. Just procedurally, in some cases, the asylum office or the ICE attorney will have that second copy of the asylum application and can file it with the court. In other circumstances, I don't know where the second application goes, so you might just have to have someone to submit to the immigration judge, and you're going to have to file the pre-hearing instructions to make sure to trigger that receipt notice and biometrics appointment as well, to get your case prepped for immigration court.
Okay, I think we might have time for one more question for Samantha. Do you have any advice or tips for practitioners assisting individuals with their affirmative asylum applications and interviews?
Yeah, so I don't want to repeat a lot of what Brian said, but I do agree with a lot of actually everything that Brian said. The one thing that I will add is managing your client's expectations. That's number one, because of last in, first out, you could have that interview very quickly. But you could also be put in the backlog, because in Houston, at least, they're not keeping up with receipts. If you are representing an Afghan client, that's fine. They're going to get their interview. They're on time for that. But if you're representing basically anyone else, there is a very good chance that they will end up in the backlog. So you've got to be ready basically for anything. You've got to be ready to go immediately, or you have to be ready to just wait a really, really long time. And so, with regards to the filing, so there's, managing clients' expectations, managing your own workload, and then the filing, it's going to be a delicate balance. So how much do you provide ahead of time, right? Obviously, ID docs, things like that, that's fine to provide now, but do you write your letter brief? I do, like Brian, by the way, I don't write a full brief, but I call it a letter brief, but it's similar. Do you write it now, or do you write it in 3 years when you have your actual interview with the law of the time, right? So that's just a delicate balance, because you can decide to put this off to the last, to the last minute, but you might be rushed. So it's a little bit, that's where you want to be careful. In terms of dealing with the asylum office, the number one thing is that it is not adversarial, and the asylum office in Houston, they're staffed with really good people, right? They're very busy, so they don't always respond on time. They don't always, but they are willing to engage, and they really are trying. So email their inbox. If you have any sort of issue, you want an accommodation, maybe you have family members that need to be scheduled together, email them. You need a reschedule, especially if it's your first time. They will reschedule without even a good cause. The email address, and please come over and ask me if you couldn't write it down. It's houston.asylum@uscis.dhs.gov. So do communicate with them. If you do email them with your G28, your client's A number, and a very detailed subject line, because they're triaged, right? So the more detail in your subject line, the more likely you will be sent to the right person. You can file supplemental docs at the window now. So do that, but they ask that you do it at least a week before. I have a few more, but I think we're up. I think some for questions.
Yes, actually, there's one on Zoom, and I think it's directed towards you.
Okay.
Since the backlog is large and takes years, can an asylee with a pending adjust status based on an employment category. Parentheses, if their employer sponsors all the steps and they make a lawful entry because it would be faster than waiting for asylum.
Yes, so I don't have any clients who, because I work for a nonprofit, so I don't have any clients who have petitions like these pending, but I do have a lot of clients who, they get married, have other types of opportunities. Sadly, they get victimized and maybe they have a U visa, VAWA, etc. So you can have several things pending at a time. And if your client is granted something else before asylum, which at this point is quite likely, what you need to do is you need to withdraw the asylum application. So very recently, one of my clients was granted his VAWA application and got his green card. So it's a very simple process. You make a copy of the green card, copy of the approval notice, and you send a letter, but that letter has to be signed by your client, right? So you can write your own cover letter, but it's got to be signed by your client saying that he or she wants to withdraw their asylum application. Do not do it before you have your green card in hand or your approval notice, because you always run the risk when you withdraw an asylum application for somebody who does not have status yet, you run the risk of getting an NTA issued. So even if you think that this is a super good case and you're going to get it granted, do not withdraw it until you actually have it approved, because you will get NTA'd. Okay.
Thank you. Are there any questions in the audience? I see one right there.
So in the case of a UAC who is in unlawful proceeding, you filed an I-289 affirmatively with CIS, and you also filed one with before PD, before the age of constitutional discretion, the best I can be hope for was a continuance from the judge. But now that we are in the age of PD, dismissals are becoming a lot more common. In that case, if you have filed both with the court and affirmatively with CIS, does the dismissal of the case mean that both are withdrawn?
So I'll repeat the question. So if you have an unaccompanied child and you filed the asylum application with USCIS, and then you also filed with the immigration court because the judge asked you to, if you get the case dismissed through prosecutorial discretion, does that withdraw both applications? And my understanding is no, that will close the asylum application before the immigration judge, the immigration court. But the asylum application that's filed, before USCIS will continue. And I assume it's likely in the backlog, so it'll just remain pending until hopefully they get their interview.
CIS denies your work authorization application, so there's no longer an asylum application.
Yes, if USCIS denies your work permit application because there's no asylum application pending, then they must have the receipt notice from the immigration court asylum application. And so I think it's a matter of, explaining that, the asylum there's a different asylum application with USCIS, which might have a different receipt number. And so giving them that information so that they can base the work authorization on that application.
Any other questions? Okay, I see one right there in the plaid.
Then when we contact the service center, they tell us to contact. So how does one contact the Texas Service Center about a receipt notice and they contact some sort of?
So I can tell you the asylum.
Sorry,
office-
can you repeat that?
Oh, I'm sorry.
The question.
So the question is, in the case of people who have waited over 9 months for their receipt notice, the service center is basically saying the asylum office has responsibility and the asylum office is saying, no, it's with the service center. So the service center has a responsibility for the receipt notices. The asylum office does not have anything to do with that. So the asylum office is not lying. If you don't have a receipt notice, they don't have the file. I think that the best thing that you want to do is document your attempts And then I would contact the ombudsman's office. I mean, that's honestly the only way that I can think of. If you've talked to the service center, the asylum office, and they both are telling you that they can't do anything about it, then the ombudsman's office is your next step. You need to really document it, but otherwise it's a fairly simple procedure, and hopefully they can resolve it, because 9 months is a lot. Your client should already have an EAD by now.
I would suggest congressional reps sometimes too at that point. You can get your congressional reps involved, or their congressional reps, whatever district they're in, to start looking into it. If nothing else, they might not get an answer, but at least it's one more person calling, and they usually have different phone numbers than we have access to, that at least lights a fire under someone.
But do check with your Congress, with your representative. Some of them want you to first have gone through the ombudsman's as well, that some of them, yeah. So do check with their office first.
Any other questions in the audience? I don't see any other questions. Oh, sorry. Yes.
The short answer is yes, legally, yes, because if the NTA was filed but has not been received by the court, if the NTA, I'm sorry, was issued but not filed with the court, then your client can still file affirmatively because they're not in removal proceedings. With that said, the big caveat is that usually, one, this might trigger ICE to actually file, or ICE or whoever to actually file the NTA. So the asylum office wouldn't have jurisdiction anymore. And the second caveat is that historically, the asylum office has refused to take jurisdiction of these cases. It's been really contentious. I've had a few. So you might have to go through an entire interview with your client to just be told that they didn't have jurisdiction, and then they file an NTA with the court, and then you end up in court. So it's kind of the long way to get to court. And do you have any different experiences with that?
Any other questions? I don't see any. Okay, so I think we're gonna go ahead and conclude this panel, and we're gonna take a break. And we'll come back at 2:10 promptly, and the break's gonna be for 15 minutes. Thank you.
Thank you. We are now into the second half of today's Joseph A. Vail workshop. Before we get going, I would like to shout out Professor Teresa Messer for scheduling and putting this production all together. What might not be obvious is there are layers of bureaucracy at a large state university, and in order to put this on, it's navigating that bureaucracy. So we could give her a round of applause. So my name is Parker Sheffy, and I'm a clinical supervising attorney here at the Law Center in the Immigration Clinic. And this panel is designed to pull back the veil of sorts about federal litigation, right? So some context, who is this panel designed for? The assumption is that we have practitioners from all levels of expertise in front of us, with a lot of expertise providing direct representation at the federal administrative immigration state, not necessarily appealing any of those decisions out into a federal Article 3 court. So the point of this panel is to provide some context and to hopefully empower you to know like what exactly an appeal to an Article 3 court looks like and how one goes about doing it. So without further ado, I'm going to introduce my two esteemed co-panelists. Immediately to my right, from your perspective, my left, is Ms. Magali Suarez Candler. She is the founder of a firm in her own name, is a board certified immigration attorney, and is a former partner in what is now Foster LLP. She is a dear friend of the clinic as one of the advisory board members, and is herself a graduate of the Law Center. Yes.
Thank you.
And then one over is Mr. Sheridan Green. He is also an alum of the Foster, what is now Foster LLP, and at the time
worked with Miss Candler at that firm. He now has his own practice, which is ranked by U.S. News and World Report as a Tier 1 practice. In 2014, he authored a petition for certiorari to the Supreme Court, which resulted in a win in the Mata v. Lynch decision, establishing circuit court jurisdiction over board motions to reopen, and laying the groundwork for equitable tolling decisions within the Fifth Circuit, of which we heard a little bit about in the first panel, and we will discuss a little bit more in depth within this panel itself. So the roadmap. First off, why is this panel here? Why are we talking about federal litigation? How is it relevant to your practice? Why would you want to bring such an appeal? From there, we're going to talk about preserving the record. In order to bring an appeal, you have to have a record. And so what does that record look like? From there, how do you appeal at its most basic? Then we're going to shift to the recent Fifth Circuit case law. And then, as the prior two panels have demonstrated, the last 10 minutes will be saved for your questions. So why should one bring an appeal in federal court, right? And so, like, to take a step back, if most of us, I guess, this panel is designed for individuals who practice before lots of experience before DHS and the Department of Justice. The assumption is you haven't necessarily appealed one of those decisions from the board out to the Fifth Circuit. We at the University of Houston are located in Houston. And so one reason why it's important is, who am I to tell you, that the approval rate for asylum in the city of Houston is abysmal. Liz alluded to that in our first panel, and to behind me, there are two graphics. One is just a Houston Chronicle article reporting as much, and then the other is track. For individuals who aren't familiar, Syracuse University has started aggregating statistics from each of the immigration courts from across the country starting in 2001. And so you'll see the number of individuals who have applied, who have been within the immigration court system, and compare that to the number of individuals whose cases are actually granted. I think it's really easy to become discouraged by such numbers, but what I would like to point out is the difference between the success rate, percentages of success rate for individuals who are represented as opposed to individuals who are not represented. And so that is why you are here, and your work does matter. So when should one bring suit in federal court? And so I'm going to now open this up as a question. So my first question is, so what types of federal causes of action do you have experience bringing, just generally, to provide context to our audience?
Well, I've been very, very busy lately, particularly doing petitions for review with the Fifth Circuit. So I've been doing more appeals lately rather than just straight federal litigation or suing the service, which I've done in the past, particularly for naturalization, mandamuses. And Sheridan has been doing more of that. So I do want to encourage you, at least from my perspective, and I've been doing this for over 33 years, and I did my first case at the Fifth Circuit in '95. I was still a very young attorney, and I did oral arguments. It was very exciting, probably one of the most exciting things I've done, except the second oral arguments that I did a few years later. But you definitely want to appeal and try to change the law, push the law. You don't want to file anything that's frivolous, of course. But, you hear how difficult the Fifth Circuit is, but I really want to encourage you. I find that the Office of Immigration Litigation are opposing counsel at the Fifth Circuit or at other circuits. I've had one at the 11th Circuit that I ended up winning because of the Office of Immigration Litigation agreeing with me. But I find that they're very reasonable. And I don't know if this is a time now to go into those details, but I do want to encourage you and let you know that almost every single one of my cases that has gone to the Fifth Circuit, I can say has had a very positive outcome for my clients, even the ones that are denied, because just doing, you know, a non-frivolous appeal where they're here legally, and I can convince ICE to keep from deporting this individual, and maybe they've been able to continue their work authorization, it really makes a big difference. And the law can change and their own personal circumstances can change. So that would be my more of a nutshell answer to why I really do like appealing to the circuit courts of appeal.
And Magali, you made a good point about there being benefits to doing an appeal that may not be a straight up win. And that's when we talk a little bit more about mandamus, that's going to be the case with mandamus as well. I've been doing mandamus cases for about 10 years, and I have never gotten to the point of a final judge's decision on a mandamus case. What happens in most of the mandamus cases is that, and we'll get more into the process later, I think, but the government generally will give us what we want to move the case, and then the case goes away. So we can't say that we've won the case, but we've gotten the client what the client won.
Yeah, that was my experience in the past with
And
mandamus
it
as well.
happens in the Fifth Circuit as well. I had a case recently in the Fifth Circuit where we couldn't have won. It was a domestic violence case. It was a good case, but it's the Fifth Circuit and it's post Haco, and we'll talk about that too. But it had really good facts, and we briefed the case. And after we briefed the case, the government decided either that they didn't want to fight us or they wanted to be able to sleep at night. And so they agreed to remand it back to the BIA. And so the case is still alive. And that happens frequently, enough to be worth filing an appeal.
Exactly, I agree. And that has been my experience as well. So we're here to really encourage you and for you to really think positively about doing this, not to think negatively and think, oh, it's all lost. No. And that's, I mean, ditto to everything you just said. Thank you.
So I'd like to stick with you. So a mandamus, a writ for mandamus, intimidating, pretentious Latin language. What is a mandamus? When have you brought them? What types of substantive or procedural rights have you sought to vindicate in bringing a writ for mandamus?
So a mandamus is a petition to the federal court to ask, and they originate with the federal district courts, as opposed to what Magali is talking about, which is the Fifth Circuit. A mandamus is a request to the federal district court to force a government agency to do its job. So the type of mandamus that you would file and the specific statutory basis of it would depend on what you are asking the government to do. But there are three aspects of a mandamus. So the substantive proof that you need to provide is that you have a clear right to the relief requested, and that the government has a clear duty to perform the act that you're asking them to do. And the third part is that there's no other adequate remedy available. So what we're usually looking for in a mandamus is some statute, hopefully including the word shall, that says that the government has to do something, and ideally to do something in a specific amount of time. So relevant to this workshop, there is a statute that I myself was not even aware of until about maybe 2 years ago, that says that the government has to give you an asylum interview within 45 days, which is really interesting, since I don't know what everyone else's experience is with the wait, but I'm seeing organic interviews scheduled in about 7 years right now out of Houston.
Yes. I don't know that I've ever seen an interview in 45 days.
Right. So we have there a statute, it has the word shall, and it says you've got to do this in 45 days. So that gives us at least a toehold. We're saying that the government or that the district court has the authority to order the asylum office to give us what we want, which is that interview. Now, it's a different question, the final decision, because the statute says hearing or interview, but at least we've been able to get some people some interviews.
What other types of instances have you brought a mandamus for?
So we will do mandamuses for long delayed adjustment of status interviews. We'll do mandamus cases to get cases out of administrative processing. We had an investor visa the other day in Canada, and we got him out of admin processing. Long delayed naturalization interviews also. And there is actually a specific mandamus statute for if 120 days have passed after the interview. So we wouldn't use the mandamus statute or the Administrative Procedure Act for that. We would use 1447B. But if you've got a naturalization which is pre-interview, where the interview hasn't been scheduled, then you can use the mandamus statute for that. We have filed mandamus to try to get the National Visa Center to schedule interviews with the consulate. We've done mandamus for employment authorization documents. We can make an argument for mandamus for a wide variety of things.
So I guess just to contextualize, right? So like a mandamus is telling the administrative state to do something, right? So that's the whole point of bringing it into federal court, is the federal court is the one that is then telling the agency that has not done what that they have a statutory obligation to do their job. So switching gears, and let's go back to petitions for review, the other type of federal cause of action that we're going to discuss today. And
Right.
so what can you provide examples of when one would bring a petition for review?
Right. Well, the INA section 242 talks about the jurisdiction for judicial review. And you can always appeal a denial of an asylum case or any relief relating to asylum. But then it gets into, since IRA, we're not supposed to be able to appeal any kind of humanitarian decision or discretionary decision, I should say. However, I do appeal those because what you argue is you are allowed to argue questions of law. So that's what you can appeal: denials of asylum, of withholding, of Convention Against Torture. But then for other types of cases where it's a question of law. So I've got a case pending right now that's a cancellation of removal case. And that requires discretion as far as a decision for whether the qualifying relative has suffered extremely unusual or exceptional hardship. But my case is dealing with the question of law of whether the child's one of the qualifying relatives should have been considered to be under 21, because the government kept this case going and continued it for 10 years. And so we've got a really good question of law there. There are a couple. I found it interesting that the government, in their brief to me, for some reason, they said something about me. Why didn't I argue something about the discretionary denial? I found that interesting. I just pointed out in my reply brief that we have a question of law, and I pointed out the jurisdictional things. But my point is that even in an adjustment case or in anything that's been denied by the BIA, any case, and I guess I need to point that out. It's a case that was at the immigration court, has gone to the BIA, and now we're appealing the BIA's decision to the Fifth Circuit. I always bring up constitutional issues. And again, I may be getting a little bit ahead of myself, but I do recommend that when you appeal even to the BIA, well, sometimes even at the immigration court level, every now and then, I might have thrown out an a constitutional argument, knowing obviously the court can't, the BIA can't, they don't have jurisdiction over that. But just in case, to make sure that I've preserved that on appeal. And there's some really weird BIA case law about that, which I don't even remember the site, and I disagree with it. But to be careful, I do bring up the constitutional issues. So those are the things that you bring to the Fifth Circuit.
So poetic transition here, because we're going to start speaking about preserving the record, right? So preserving the record, Magali makes the statement that the statute speaks about questions of law, right? Meaning there are certain questions that are not appropriate to bring in federal court. Those issues need to be raised below.
Exactly. So you want to make sure, and we'll talk a little bit more about this, you want to make a good record, of course. So don't allow yourself to be bullied. Now we're getting a little bit into, just what you may have already talked about at another panel. But when you're in court, make sure you make a good record. Don't allow the judge to be looking at his or her watch. Not that they do that. And I have a former judge here in the audience. He never did that. I want you to know. But, I've had judges say, Miss Candler, where is this going? Or they're looking at the clock, they're looking at their watch. And I will tell them, I'm making my record, Your Honor. you know, and you just put whatever you need, whatever facts you need, you make sure that you've asked those questions, you get it on the record. And the only time that I guess with all the PD, prosecutorial discretion that's going on now it's a little bit, there are times that a government attorney might say to you, well, if you just let me make a few questions, let me ask a few questions about their criminal record or whatever, then I won't oppose the case. But if I do agree to something like that, I make clear too that I will make a record if for whatever reason the government does not end up agreeing. And I'll say something like that on the record when we tell the judge that we're agreeing to some sort of, you know, shortened hearing. So number one, make sure you've got everything that you need on the record. But when there are questions of law and you've argued some things to the judge, that the elements are proven, or that you believe your client, I don't know, I'm trying to think something in the elements of the relief that you're asking for, and you see that the judge is maybe making an incorrect decision. There are times that the judge might say something in court that makes you know this, and you try to, in your closing argument, address it. But I just want to make sure that you've addressed everything that you need on appeal later, because, and also do remember, obviously, the applications are part of the record, your supplemental documentation is part of the record. So don't forget that when you're doing your appeal too. But it's better to try to get everything on the transcript if you can, including your legal arguments. So, you know, try to make an opening argument. Definitely push to make a closing argument. If you can, ask for a written closing argument. But those are things to keep in mind for making a good record for appeal.
And Sharon, you made the statement that a good record is, you know, and you see it, right? Like the Supreme Court talking about lewd material, you know, and you see it.
Right.
So what, I mean, I guess to build on what Magali was stating, like, what does it mean to preserve the record? What does a good record have? At a minimum, what should be in every asylum application? What does it mean to have a good, thorough record?
So it means a couple of things. And specifically, there's a jurisdictional statute, the exhaustion statute, and this is going to be, you know, particular to the Fifth Circuit as opposed to the BIA. But it says that the court may review final orders only if the alien has exhausted all administrative remedies. And that for the Fifth Circuit actually means two really quite different things. Number one, an administrative remedy means, you know, you have to go to the BIA before you go to the Fifth Circuit. You have to get a final order from the immigration judge before you go to the BIA. That's what most of us think of when we think of administrative remedies. But the Fifth Circuit expands that into a jurisdictional sort of issue waiver rule, which means if you don't bring something up below, the Fifth Circuit will say we have no jurisdiction to touch that. And as an appellate lawyer, you always wish that you had a time machine, because you're always wanting to go back in time and get something on the record or get something entered or make an argument, make a legal argument that was not made below. And a lot of times this isn't even anybody's fault, because so much time passes between the various levels of litigation that a case will come out, which will make an avenue for relief available for you that wasn't available before. And you had to have been able almost to see the future, to know what argument you could have made that would have done you no good at the level below, but will be critical 2 years in the future. So on that note of waiving issues, the number one reason why issues die at the Fifth Circuit is because they weren't brought up below. And of course, the reason they weren't brought up below is because the lawyers were focused on other things. They were arguing about other things, and they left some little thing out. And then other issues got resolved on appeal, and that little issue became the critical issue on which the case turns. An example of that is we had a Fifth Circuit case about 2 years ago. Again, it was a domestic violence case. It was a really good domestic violence case, and the lawyer had done a good job. And he put a lot of really good stuff in the record that was really helpful on appeal. There was a psychologist report. There were all sorts of articles. It was much more than just the bare minimum Department of State report, which you can find a lot in there, but the more effort that's been put into that case, the better that record is, the more stuff you can find on appeal that you can get a toehold on. And everything had been covered except for an issue. And that issue was whether the government of, it was probably Honduras, had been, whether it had been shown that the government was unable or unwilling to protect the defendant. So that issue had gotten waived at the BIA level. It had been argued to the immigration judge, but it had been dropped at the BIA level. And at the Fifth Circuit level, that could have killed us because the government in its brief basically said nothing, but they left out this one thing. That one thing did not get preserved, and without a showing of that, none of the rest of this matters. And you had asked me, Sheffy, Parker, I just did it.
Sorry.
You have two last names. You had asked me what you can do on appeal to try to get out of that. And again, a lot of being an appellate lawyer is trying to weasel out of little mistakes like that. And I thought about that, and what we actually did in this particular case was, even though this lawyer, who was a very good lawyer, had not argued the unwilling or unable to control element, he had argued for Convention Against Torture. And Convention Against Torture requires an argument that the government acquiesced in the torture. And so we argued that that actually goes even further than unwilling or unable to control. And so in essence, the argument had been preserved.
Yeah, that's a great argument. Yeah. I wanted to make a comment about new case law. When something like that happens, I want to encourage you, because, you know, we can't see the future. Every now and then I've kind of known that something's pending at the Supreme Court, and I just start arguing it and telling the judge, I know they're going to decide like this, like Miss Candler. The Supreme Court hasn't made that decision yet. But what I was going to say is, when you do get a new case, I do want to encourage you as well to do motions to reopen or motions to remand. Don't forget your motion work, because it then also helps you later on appeal. I was just mentioning to Parker earlier that a lot of my appeals lately too have been appeals to the Fifth Circuit of motions to reconsider. And guess what? That's where I won. That's where I ended up winning. So don't forget to do your motions, and you can do petitions for review on your denials of motions to reopen or motions to reconsider. But that's what I thought of when you mentioned the new case law. But yes, it's hard to know and see the future. And I do a lot of both. I do the case work, you know, I do the court work at the immigration court, and I like to do my own appeals when I have to do appeals, and I do appeals for other attorneys. But it is hard to know everything, to try, but you still try to cover each and every element, and thinking exactly that if you don't get it covered, the government will eventually argue, oh, look, they waived it, or they didn't, you know, that's it. The case is lost because they didn't mention it. I love the way you all got around that. That's great.
As you're speaking, it makes me think of like one thing I just like to highlight is that to preserve the record, it's both the facts and the law needs to be sufficiently developed below, right? And so it makes me think of like why this is a practice, because in order to know the law is an ongoing skill set, in order to adequately explore the claim, in order to build the record is an ongoing skill set. So both the facts and the law need to be sufficiently developed at the trial stage. And then as the case progresses, well, then that's where, okay, the law might change and you might implicate the motion to reopen forward looking.
Right. And it's good to do motions to reopen based on new law, if you can, within 6 months of the change, if you can.
Oh, golly, you're always very predictive, because now how to appeal. So speaking about
There you go. Yes.
So starting with petition for review, when can one file a petition for review?
You've got only 30 days. That is it. It's by statute, and there's no way really to change that unless you can get the BIA to issue a new decision. And I have seen that happen. I've helped that happen in the particular case. So I know that it can be done, but you don't want to have to go there. So if you're going to do a petition for review to any of the circuit courts of appeal, you must file your petition for review within 30 days. The great news is you can do it electronically. I haven't checked with the 11th recently, but the 5th, you can do it electronically from the start. For a long time, you had to do the 5th on paper for the petition for review, and then everything else electronically, which never made sense to me. But now you can do it all electronically. So do that within 30 days. That's very important. And the petition for review, you know, I didn't even think of it. We maybe could have given you an example. Maybe we'll give one to the school to put it maybe with the materials, because it's very simple. You just want to make sure it's less than one page. Really, it's just letting them know that you are appealing this decision, and you attach the BIA decision. And that is it. It's really very, very straightforward, but you must do it within 30 days.
Yeah, that's exactly where I was going to
Yeah.
go. It's like 30 days sounds really daunting, right?
It is.
And the spirit of encouraging individuals to do it is actually filing a petition for review that involved.
But no, the petition for review itself is very, very simple. The only thing is that, you know, you've done it, now you're on the hook. So, you know, either you're doing it pro bono or you're being paid appropriately to do what's coming, because you're going to be doing an opening brief, you're going to be doing a reply brief. That is a definite. You'll be doing both of those. So, you know, and you may be able to ask them to hold the case in abeyance, perhaps, if you're doing a motion to reconsider at the BIA. And by the way, I recommend for everybody. In fact, I really must insist that you do a motion to reconsider at the BIA when you file your petition for review. And at some point, some courts, sometimes over the years, I've been able to get them to hold the briefing schedule until I get a decision from the BIA on the motion to reconsider. But the reason, there is a case, and I'm sorry, I don't have the case, but just listen to this, it's true. The Fifth Circuit may give you a really hard time if you don't ask the BIA to reconsider a decision. I don't agree with this. I think it's wrong, but I've had a case where the client really didn't want to do the motion to reconsider. And thankfully for her, she has another way I'm going to be able to save her. But it really hurt us on the appeal that we had not done a motion to reconsider the decision from the BIA. But anyway, you'll file your petition for review. You have only 30 days. I recommend a motion to reconsider with the BIA, and you only have 30 days for that. And both of them can happen at the same time. You have no problem with jurisdiction. The Fifth Circuit can take jurisdiction of your petition for review, even while you're asking the BIA to reconsider their decision. The only thing is that, you know, if you're me, you really would like to see them hold your case and not have to brief it until you hear back from the BIA. Why? Because if they deny it, I'll do another petition for review, and then they combine them and you can do maybe just one brief instead of two. But no, recently, I will say for the Fifth Circuit, they're so great on a lot of things, but I've seen them recently not agree so much, even when the Office of Immigration Litigation is agreeing to ask them to hold it in abeyance, they're just not doing it. So I've had a lot of cases recently where I end up having to do two briefs, and two reply briefs.
I don't know why the Fifth Circuit does that.
Yeah, it makes no sense.
Yeah.
And, you know, I've done this so many years, for many years, it was just a given. All I had to do was let them know I had a motion to reconsider at the BIA, and they would hold it in abeyance. That was it. But anyway, now it's a little bit more difficult. I've had them do it maybe in 2 cases out of 10, let's say, in the last few years.
Again, it's like the idea of not having the case law, but I would encourage you to push back in the event we're getting to the exhaustion, right? You need to raise everything below. In the Fifth Circuit, the law that there is a precedental decision that you do not need to file a motion to reconsider in order to exhaust administrative remedies, right? So you should still be able to bring that petition for review, even though you may or may not have filed that.
Absolutely, absolutely.
Can I say
yes,
something on that,
yes.
Magali? So I only know this because I got a text about it yesterday, but the Supreme Court has taken that issue up. In the Santa Zacharia case, which I think is a Rayad Gonzalez case. The Supreme Court has now taken that case, and it is on the issue of when you need to file a motion to reconsider before the Fifth Circuit will hear it.
Right.
Santa Zacharia is a transgender woman in Honduras. And the BIA had engaged in impermissible fact-finding. There's a dissent in the case that explains what went wrong. The Fifth Circuit says, regardless, you had to file a motion to reconsider and bring this up with the BIA again. That is now with the
Yes.
Supreme Court.
Well, and I hope the Supreme Court rules, you know, the way we would like to see, because I don't think you have to. But again, the reason I encourage you to is because of this, what the Fifth Circuit does. And I've seen it again and again. So it's almost become a common practice for me to do motions to reconsider if we can.
That's helpful.
Yeah. But I'm looking forward to that Supreme Court decision. I'm hoping they decide correctly like they did Pereira. I always told the judges how Pereira was going to come down. They're like, you don't know that, Miss Candler. Later, I could say, oh, I was right.
So Sheridan, I'd like to say with you then with the writs for mandamus, right? In the same, how does one do this? Can you just describe the process, the timeline of filing? What does that process, the life of a writ look like?
So, and I'll talk about it in the context of an asylum interview mandamus, just because that's what we've been doing a lot of for the last year and a half. There was a time when we could file an expedite request with the asylum office, and I felt like they were fair about it. Sometimes they weren't quick about it, and sometimes they'd say, "Hey, can you be in El Paso in a week?" You'd have to call the client and say, "Hey, you willing to fly to El Paso to have an asylum interview?" And eventually, the asylum office stopped doing that. So we started filing mandamuses, get asylum interviews. So the first question that I would ask a client would be, "How long has this actually been pending?" And just through trial and error with the Houston Asylum Office, we've figured out that they will fight us if it's anything less than about 5 years. So if the case has been pending for longer than 5 years, generally, I guess I'm getting ahead of myself, but generally a mandamus will have a positive result in that we'll get that interview and we can dismiss the case and not have to worry about going into litigation. But anyway, that's the first question. The second question is, what's the level of confidentiality here? Because there is the possibility for complaints filed with the federal district courts to end up searchable on the internet. It doesn't seem to have happened much in the last couple of years, and I think that's because of changes with ECF, but I'm not entirely sure why. It seems to be a little more secure, but I'm very concerned about asylum clients who are, worried about their government knowing where they are, having all the details of their asylum claim in a complaint which shows up on Google. Wow. And then we have figured out how to file these sealed to make sure that they don't show up on Google. But anyway, that's the second question, is how worried are you about confidentiality? Because you don't, with the federal district court, necessarily have the guarantees that you have with the asylum office.
Wow.
And so if they're okay with that, and if it's been pending for 5 years or more, the first thing that we would do is, I guess I'll go down kind of a level in terms of just federal litigation. To file a petition with the federal district court, you've got to be admitted to the court. It's not too difficult to get admitted to a federal district court. It generally requires a certificate of good standing from the state bar. And for a while in Houston, you had to take a class. I'm not certain if they still do it that way. Once you're admitted and once you've got your ECF password, you can write up a complaint. And it might take a week or so to write up a complaint, file it online with the court, and then you're going to get an email with the receipt. So at that point, your litigation is pending. At that point, you need to serve the government. The way that you serve the government is by filling out a summons, and the summons, you can find them online, and it says who the parties are in the case. You fill out the information, the summons, you send it to the federal district court, either on the ECF or you bring it in person, and the clerk will stamp it. And once it's been stamped, you've got to get it principally, you're supposed to serve the summons and a copy of the complaint to all the defendants, but principally you're trying to get a copy to the assistant U.S. attorney downtown at the U.S. attorney's office. Send it certified mail or take it in by hand. And at that point, the government is served. And what happens procedurally is once the government has been served, they have 60 days to respond. And that's in the federal rules of civil procedure. The government, when you're suing the government, they actually get a longer time to respond than a normal defendant. But that 60-day period is critical because oftentimes the government finds it expedient to, rather than answer the complaint or rather than fight you tooth and nail, to call up USCIS on the phone, in this case, the asylum office, and say, hey, tell me about this case. Can we get this interview scheduled? And sometimes the asylum office will say yes, and they'll schedule the interview. The assistant U.S. attorney will send us a copy of the interview notice. We'll go to the interview. Hopefully everything goes well. Hopefully we get a decision, within 2 weeks after that, before the government's response deadline. The government will, from time to time, ask for an extension of that deadline, which we can give them if necessary. Best case scenario, the asylum is approved, everything is moot at that point, and the government will ask us to file a stipulated dismissal, or the government will file stipulated dismissal on our consent. That is generally the life cycle of a writ if all goes well. If all does not go well, if the government decides they want to fight us, they can respond. And a respond is usually a general denial. And you may or may not have seen a general denial, but it goes through your complaint paragraph by paragraph and says, we deny this, we deny this, we admit that, we deny this. They don't even have to have read the record to write a general denial. And at that point, they can file a motion to dismiss, or they can wait for the judge to go through the judge's process of issuing a scheduling order. Sometimes there's a hearing for that, and the judge will decide what will be due when. At that point, the case is decided on motions for summary judgment.
So, just for the panels, we have about 7 minutes left before we're going to get into the 5 minutes, or rather the last 2 minutes for questions. One point, so Sheridan made the statement that you have to seek admission to the Southern District. So writs of mandamus, district court, petitions for review, circuit court of appeals, right? So
Right.
it's separate.
It is separate. Thank you. It depends on which circuit you're going to. Each one has, the rules are a little bit different, but you're always sponsored by somebody who's already licensed in that federal circuit court of appeals. So I'm regularly at the Fifth Circuit, and Jeff Hoffman, in fact, was my sponsor for the 11th Circuit about, 10 or 15 years ago, a long time ago, when I was going to the 11th Circuit. But you just apply, and you also do need to show a certificate of good standing from the state bar. And it's really, and you don't have to take a class. So I really do encourage you to become licensed at the Fifth Circuit for sure. If you're practicing here, why not? But it's really quite easy. I wanted to say my experience with mandamuses have been the same with naturalization, particularly. Never really had to finish litigating it. We ended up getting our decision. I just wanted to say something which is really a little question to my panelists, and Sheridan particularly. Something I always used to worry about with mandamuses is, what if you get a decision you don't like? You force them to make a decision, but it's not the decision you want. Do you have a comment on that? I mean, I really meant to ask you just what your thoughts are on that.
That happens sometimes, and that's something that you always want to advise a client of, is we are asking for an expedited decision, but that doesn't mean the decision will go in your favor. Now, there have been times when we have gotten a negative decision on something, and this wouldn't an asylum wouldn't count here, because obviously the appeal for an asylum goes to the immigration court. But there have been cases where we got a decision for a case as a result of a mandamus, and we wanted then to ask for a review of that decision by the court, which is a different statutory basis, because we're not asking for something to be expedited. We're asking for the court to review it, presumably under the Administrative Procedure Act, because the courts also have some availability or some jurisdiction to review decisions. So we might amend the complaint. We might amend the mandamus complaint and turn it into an Administrative Appeals Act review complaint, and then keep it going.
Yes.
So that does happen sometimes.
Yeah, and I've seen that with citizens at birth, things like that.
Yeah.
And asking the court to review someone's citizenship. Yeah.
Yeah.
Very good. Thanks. Yeah. But it is something to keep in mind.
So here's the last question, rather open-ended, before we turn to our audience. To contextualize, so like in the first panel, we were provided a lot of case law. So I guess, is there any recent Fifth Circuit case law or otherwise that would be helpful to contextualize and discuss now?
Yes, I know that Sheridan and I had discussed this and we wanted to talk about HACO, which I think was mentioned in the first panel. And it has to do with domestic violence. I don't know if I really wanted maybe Sheridan to take the lead on that. I wanted to mention very quickly, it's not necessarily related, but it is an important Fifth Circuit case, Duarte versus Mayorkas. For those of you who represent people who've got TPS and they've traveled on their advanced paroles, this decision, I don't even know that I necessarily agree with the law behind it or the decision, but it is actually positive for our clients for the most part, because now USCIS is not applying matter of ZRZC, and they are allowing anybody who traveled on advanced parole after August 20th of 2020 to be able to apply for adjustment because it is an admission. They're treating it as an admission. So that's an interesting thing. I've always, it's a long story. We're not going to get into why it is that now they say that's an admission. Whereas other people, and they're going to create a new document for people on TPS to travel, because their advanced parole is going to be different from other people's advanced paroles. They're not going to be paroled in, they're going to be admitted. So, but I think that's very important, the Duarte versus Mayorkas decision. And then the Rodriguez case, which I do think is a Red Gonzalez as well, that decision from April of 2022, the en banc, they still decided that Nice Chavez does apply to motions to reopen. The problem is, and I don't have the case names for you, but you start looking at those Fifth Circuit cases from this year on motions to reopen, and I was going to get oral arguments on one. And then they took my oral arguments away because they started trying to find ways to say that Pereira and Nice Chavez don't apply to motions to reopen if people, for whatever reason, didn't give their address change to the court. And it's really, if you saw some of the facts that they're using, and my case was not a published one when they denied it, but they ended up, instead of giving me the oral arguments I was going to get, they ended up denying it. It is very upsetting because I don't see Rodriguez then being expanded. They're finding ways to really limit that. But I just want to open your eyes to that. And then, of course, I have to mention Gregorio Osorio, because that was my Fifth Circuit case, that there's a little short published decision saying that Nice Chavez applies to voluntary departure. So the time doesn't stop. Your client was NTA'd with a putative NTA when they were caught at the border. That doesn't matter in the future when they've got their hearing. If they want voluntary departure or need voluntary departure, they are eligible for it. The time doesn't stop with the putative NTA. So anyway, just had to mention those. Do you want to discuss Jahaco a little bit? I know it's question and answer time.
Sure. I mean,
Jahaco's important.
I'll just talk about it briefly. It's hard to know what to say exactly about HACO other than just be strong. But
I'm appealing a case where I'm fighting HACO. Yes.
So basically, just to summarize what happened, I think we're probably all aware of Jeff Sessions' decision in AB1, where he basically said that any asylum claim which is based on persecution by a private group, including domestic violence, is almost never going to be a valid claim. It was some very strong language that he used, and the Fifth Circuit agreed with that. And then Merrick Garland in AB3 came out and withdrew AB1. It said, no, we disagree with that, and that's caused all kinds of problems. And the language was too strong. And we were all, of course, very excited about that. And then the Fifth Circuit came out in HACO and said, you know what, we still like AB1. So it's hard to know what to do with that as a practitioner. I wonder if there's some sort of essentially, you've got the Justice Department, which, you know, the BIA is part of the Justice Department on one side of an issue, in terms of whether you can make out any kind of, you know, domestic violence based claim on one side, and you've got the Fifth Circuit on the other, and they're sort of disagreeing with each other. And who prevails in that instance? I almost wonder if you can make a Brand X argument that the agency actually gets to interpret the ambiguous statute.
I don't know. If
But
my
do
case
you have
gets,
any ideas?
I'm appealing a case like that to the BIA right now. And I tried to distinguish Hako by hanging my hat on this footnote, or just this little, kind of tiny dicta saying that this doesn't foreclose all domestic violence cases.
Right, and Taco says that, that's a.
It does say
paragraph.
it's
Yeah.
there. Yeah, it's, I don't know if it's a footnote, but it's there. And I mean, I was citing it big time. I cited it all over the place, but that's what I'm doing right now. My case is at the BIA right now. So it may then eventually get to the Fifth Circuit. We'll see. Yeah, I was very not happy about Hako. What can I say?
Jeff Sessions, I mean, AB1 would make the argument that AB1 wasn't to foreclose domestic violence in general, right? Like it's still
He
an
said that too.
individual-
I remember him saying that
Yeah.
at some point, or it's saying it.
Not to apologize
Uh,
for Jeff Sessions.
Believe-
No.
I think the words were
Let's not.
almost never, I think that's.
It's something like that.
Those
Oh,
theories.
almost never.
Almost quasi categorical, yeah.
Right.
Okay, so with that, we will turn to you all. Or do you have any questions for our panelists? And to just FYI, we're going to repeat the question back to you because we have individuals at home, so they can't hear you, but if we say it, they can.
For both hearing statements, I know they don't have to go on the record, and they can refuse to go on the record. So for a bond appeal, you have any suggestions if the judge refuse to go on the record, so we don't have the grounds for abuse of power?
Yep.
Have you ever tried to include some other type of evidence of this abuse?
The question is about bond appeals because there is no record. Even, and I've done a lot of bond hearings where we weren't being recorded, but they won't do a transcript. And that is an issue. So the question is, how can you appeal if they don't have to go on the record, but honestly, even if they do, you're not going to get that transcript. It is a problem. How do we appeal it? How do we preserve, what do we argue? I've appealed bond hearings arguing what we argued and with our evidence in support of the bond. And the times I've had to appeal have been when the government, I'm just trying to think one time. Oh yeah. Okay. One really big one that went to the BIA and the BIA went our way was the judge denying any bond at all. And you just do what you can. I remember putting in all the evidence that we had submitted and our legal arguments. And obviously the judge had denied it. But I understand because you're saying, how do we show that the judge abused their discretion when you don't have? But you know what? You can make your own offer of proof. I don't know. It makes me even think about bringing a witness to say, to do a sworn statement saying, well, the judge said this and that. But
We have several. So I was thinking.
Well, and the question is, they had people from their office observing, so could they? Honestly, why not? I mean, it depends. I'm just thinking of a judge denying bond, and then you're showing the BIA, look at everything we submitted. This person, obviously they deserve bond. But if the judge maybe said some things that were very prejudicial or really ugly on the record, yes, that's why not? Put in an affidavit from someone who is not you, who was there, who was a witness.
We actually have a Zoom question relevant to this. So what is your take on the reviewability of discretionary decisions after Patel v. Garland?
Yes, and that's funny. I had Patel v. Garland in my notes, but we didn't really get into Supreme Court decisions. My hope is that the government will not start using Patel versus Garland. It's a Supreme Court decision. And I'm hoping they won't use it to say that, for example, appeals of adjustment of status can't be done. That case is one that's based on a perm and on an adjustment of status. And I think that we can still, first of all, you can always argue questions of law anyway. But so far, I do believe that if you had an adjustment of status denied at the immigration court level, you could appeal that to the BIA. So I don't see a problem there. And I don't see any changes in being able to argue questions of law. I was very freaked out after Patel versus Garland when I was writing my first Fifth Circuit brief after that, worrying, is the standard of review the same? And when I really thought about it, and just really considered it. I didn't change my argument as far as the standard of review. So I would say treat Patel versus Garland somewhat as an aberration, and don't let that stop you from making your arguments on, for example, judicial review to a circuit court of appeals, arguing that you have a question of law. Because no matter what, you're not supposed to be able to appeal to the Fifth Circuit or to any circuit court of appeal, the discretionary decision itself. So you always have to couch it in terms of there having been some legal standard that was violated and or a constitutional violation. And that's how you have to think of it. So like Sheridan said about Hako, be strong. So I say be strong. I'm not going to let Patel versus Garland affect me, but it's a great question. Thank you for asking it, because I had thought about mentioning it and then I thought we just didn't have time. Omari v. Holder, 562-314, 2009 Fifth Circuit case, Omari v. Holder. Martinez Guevara or Guevara, anyway, probably Guevara. Yes. Versus Garland. What is this? Do you have the cite for that? These are the Fifth Circuit cases talking about exhaustion of review of 20-60624 for Martinez Guevara versus Garland. And these are cases regarding the exhaustion of administrative relief arguments. Motions to reconsider. Yes. Yes.
You should have filed a motion to reconsider if the board didn't consider it, otherwise.
Yes, thank you, Judge Zimmer. I will mention this to everybody. This is what happened to me in a case where my client didn't want to do the motion to reconsider. The judge was saying that the way you sometimes miss an issue, and this has happened to me, but because my client didn't want to do the motion to reconsider, what happens is you bring up an issue to the Board of Immigration Appeals, and then they ignore it. You do your petition for review to the Fifth Circuit, and the Fifth Circuit turns around and says, you know what? You should have done a motion to reconsider for them having ignored it. Now, I want you to know that I was very angry about that. I asked for for a panel, reconsideration of that, and they denied it. But we'll see what happens with the Supreme Court case, because I argued that there was no, why should I have to do a motion to reconsider when that was preserved? It's, I have to let the BIA know, hey, you ignored this, please reconsider it, for them to say, no, we didn't ignore it. We just really we don't like that argument. We're not. So yeah, it's very frustrating, but it's a very good point. And that's why I ask for you to try to remember, at least for now, and we don't have a decision from the Fifth Circuit, from the Supreme Court, when you can do your motions to reconsider.
So with that, we have reached the conclusion of this panel. If you have any questions, we have a wealth of resources. I'm sure the panelists would be happy to answer your questions individually, but the panel is done. We have 5 more minutes and then we'll have our final.
Thank you all. Thank you, Parker. Thank you, Sheridan. Great job.
Okay, thank you all for the availability for such a long day. I know you've heard a lot of information, and we'll try to move through this last panel so you get your 4th and final welcome to the new building. It's brand new, beautiful, and also with some tech difficulties. So apologies in advance if there's any feedback. My name is Lucas Eisenberg. I'm one of the clinical supervising attorneys at the clinic. You have my boss to my far left. So if you have nice things to say, say them to her. If you have negative things to say, keep them to yourself. And with me at the rest of the panel, I have Dr. Ann Webb and also Dr. Guillermo de los Reyes, who are mental health experts and country conditions experts, respectively. So we don't have a lot of time, so we're going to be moving fairly quickly. If you do have questions, I promise my best that I will try to get to them towards the end. So as a little bit of a roadmap for where we're going today, we're going to be discussing a theme that has been present through the entire presentations today of building that record. So we're taking it back to the beginning stages of what exactly are we providing to the immigration judge and eventually through the processes of appeal to various agencies and courts in the federal system. So why are we using experts in removal proceeding? What type of experts exist? Where to find them? How to work with them? And towards the end, we're going to see 2 examples from each of our experts of what they look like and their reasonings behind those kinds of divisions. And also for the people on Zoom, I will be able to see your questions towards the end. So generally, there's 3 types of experts that are the most common in the removal proceeding settings. We have a mental health expert that will attest to various things related to mental health, a country conditions expert, which is fairly self-explanatory, that will discuss the sociopolitical context of those countries that are the places where our clients are fleeing from. And lastly, medical experts that are, at least in my experience, the least common of the 3.
That's because they're expensive.
They are expensive, that is true. But you can negotiate accordingly. So why use experts in removal proceedings? It's essentially a piece of evidence that will be crucial for us meeting our burden. It's one of the unfortunate realities of immigration practice that the burden of proof when applying for some forms of relief is always on us, us as the attorneys for the respondent. So in most instances, for at least asylum or fear-based claims, the clients have suffered a history of trauma in their home countries, or for U visa clients, they have suffered through some criminal activities here in the country. And we want to get that evidence on the record for the judge to be able to assess accordingly the weight of the evidence we're providing. Experts are also useful in corroborating country conditions, statuses, and trying to explain what a return to that home country would look like for a particular respondent. So moving quickly, I know where to find these experts. Generally, you can find them wherever you look. The easy answer for me, because I work at the University of Houston, is to start by looking at the universities. Generally, you can look them up online and ask for their political science departments or history departments or some sort of liberal arts department to find the country conditions experts, and then the social work schools or psychology schools to find mental health experts. So that is my cheap answer, because I have 2 great examples next to me. Also, you can ask your peers in your community organizations like AILA, for example, the various listservs that we have here in Houston through like HILSC or other organizations from back when you guys were in your respective law schools or undergraduate schools. CGRS is a nonprofit based in UC Hastings, the Center for Gender and Refugee Studies. They are a great program, and they have a huge list of experts that people can refer to and email or contact somehow to try to see if they're willing and able to take on a case for representation. And lastly, as part of our common practice is to look for country conditions articles. There's live human beings who have written those articles. So much like a law school student, you can cold email them and ask for assistance or at least availability. So choosing the right expert. We need to think about what are the goals, right? So not only the division of, is this a medical expert that you're trying to get, or a mental health expert, or some kind of country conditions, because that will be very easy to figure out when you meet the client and assess their needs. But what exactly are the issues that you're trying to resolve with this expert? Are you also going to be able to pay the expert? And I use generally, but it's the client able to pay the expert, or are you going to be requiring pro bono or low bono assistance? And that's something that, of course, you will be able to communicate, to foreshadow a little bit one of the next slides with the experts to assess who is a right fit to assist you in presenting your case. Is there going to be live testimony necessary? One of the earlier panels, I think, discussed PD and getting cases out of court, and that we don't really have a lot of leeway to figure out in advance whether OPLA wants to dismiss cases ahead of time or not. But still, at least as
as a beginning stage of a theory, do you want to ask this expert to testify in front of a judge? And if so, is it something that is feasible for both parties? And of course, keeping in mind that the date for a hearing is subject to change with little to no notice in advance. And of course, with that, what is the timeline? Because the experts, at least the ones from public entities, will have their own either class load or course load that they're teaching, and the ones in private practice will have other clients. So we need to make sure that the schedules fit not only for us asking for help, but also for them providing that help. So with that said, I want to turn the question over to the experts at the table to discuss what do you like to see regarding communication from practitioners?
Well, we start with releases, consents. Lawyers are usually really good about that, but I think sometimes non-lawyer experts might not be as familiar with those specifics. So you want to make sure that both as the expert, I can hear what's going on in the immigration case, but also that I have permission to talk to the lawyers about what I have learned or what I found out. So that's the place that I always want to start, is let's make sure we have those consents and those releases signed. And then usually the second question I ask is, how soon do you need this? Sometimes it's next week. Magali, I'm looking at you. But other times it's going to be, 2 months, 3 months out. And so that makes a big difference, having that information. And then again, the question about whether you need live testimony, is it an affirmative asylum case where that is unlikely, or is it going to be a removal proceeding where there might very well be an opportunity or the chance to testify? So those are kind of my things.
Yeah, I just would like to add there that some of the experts, for example, in the case of country conditions, might be seasoned experts that you don't need to explain too much about the country conditions report. However, there might be others, as myself 12 years ago with the law clinic here, immigration clinic here at US Law Center. That was my first case in 2013, and I didn't know what to expect. So walking through the process, the expert, you as lawyers, the expert, examples of affidavit, talking about the deadlines, that's very important, and the possibilities for a that they need to testify and so on. So I think it is important to communicate. That would be something to have a good understanding of communication with the expert.
I guess this one's still me. So when you are asking me for a report, if I've done a lot of these at this point, so I'm pretty comfortable with preparing a report from scratch. But if you're working with someone who is new, who's never done a report before, these are the sorts of things you're going to want the report to include. And we'll have some examples from both of our reports towards the end of the presentation. But you're going to start off by just providing a diagnosis, if there is one. It could be end-stage kidney disease if it's a medical expert. It could be depression or PTSD if it's a mental health expert. You want to talk about what the treatment is what treatment is necessary for that condition, specifically dialysis, for example, or talk therapy or medication therapy in the case of PTSD or some other mental health or behavioral health diagnosis. And you want to talk about both what the end result might be if they're being treated in the US versus what might happen if they're being treated in their home country. So is dialysis actually available if you're from a small country or small village in Honduras, for example? Is there mental health care? Are there psychiatrists, for example, available to the population at large in Nigeria or somewhere else in Africa? So you'd want to include those. And so one of the things I also do when I'm writing a report is do a little bit of the country conditions stuff. That I leave the hard stuff and the big stuff to the country conditions expert. But if I need to know whether someone can get this treatment in the country of origin, then I usually look that up myself, and I will rely on publicly available sources. Sometimes that's as easy as Amnesty International or Human Rights Watch. Sometimes the World Health Organization will have information about mental health care in Africa. So I will incorporate that into my report as well. So I absolutely include a discussion about how would deportation impact the condition, treatment for the condition, long-term survival, things like that. So, yeah.
So what to ask to the country conditions expert? Please ask them to provide an objective and independent sociopolitical analysis and historical of the context in the country that they will be. In my case is Mexico, and tell them that, for example, in my case, I'm a country conditions expert for LGBTQ plus individuals. So tell them to give the report on that particular aspect, that they should not go try to give their opinion on an area that they are not experts. For example, I would never provide, I might mention about, for example, drug cartels in Mexico, if they are relevant, but I cannot provide relevant information because it's not my expertise. And also, it's important to contextualize the interactions with local enforcement agencies or lack thereof of the client, and explains the government's ability or willingness to protect your client or people like your client. And here it is important to also, as I mentioned before, give them an example of what a country conditions report is. And there are examples around. I found one of the ones that I wrote somewhere in the World Wide Web, and I was happy that other people were able to get an example of what it is. But that's something that you need to ask your the expert that might help you.
Thank you. And that brings us to a good point that preparation is important and not imputing knowledge on the experts, and also the other way around. So that open communication. I am a huge fan. Obviously, I work with students, and so I encourage multiple rounds of preparation, as you guys did early in the semester. So you will see that during the next few months. But it's very beneficial for all parties involved, at least on the defense side. I don't think OPLA or the judges care what we do. But if we have multiple practice sessions, we'll be able to iron out any awkwardness or some questions that are poorly drafted to allow the expert to testify properly as to the issues that are pending before the court. So you can also ask the expert, as Guillermo was saying, the level of expertise of each expert, how many times they have testified. Of course, these are things that would come up during voir dire, during the course of the proceedings. But the earlier you know, the better, so that way you can plan ahead. So if I meet someone like Anne, who has been doing this for many years, then I know that I need less interaction because she knows what to do. But if I meet somebody...
But the interesting thing, though, is that most of the time I do written reports and I never actually testify. So I've only probably testified live in a handful of cases. So that being said, I would definitely be grateful for the opportunity to do a prep session, at least with students or with the lawyers, so that I would be comfortable with what might be thrown at me during that live testimony.
Yeah, with me, you don't have to ask twice. I'll give you as many rounds.
It might also really be helpful if you got staff to do it, to actually play both sides. So having one, I think this is really helpful in clinic settings where one student can role play the trial attorney, the government attorney, in order to prepare both themselves for the actual trial, but also to prepare the expert for what hostile questioning might look like under those circumstances.
Right. Then also within that practice, it will be relevant in terms of, related to the country conditions expert. Sometimes I have testified a couple of times, one live and one over the phone, and there will be some questions from the government about the expertise, the expertise of the person. Some questions regarding not only their knowledge about the country, but also their expertise. So it is important that you practice with that.
And another thing to consider are the evidentiary issues, because we're now working in a universe that we create, but we work in a universe that is established by a system. So outside of the obvious answer of don't forget to check the practice manual for when and where to submit the resume of a particular expert, you also want to prepare for the worst. So what happens, for example, if you want to offer this proof, so a proffer of the experts to the judge. So you're saying, if allowed to testify, Dr. De Los Reyes would attest to the conditions of LGBT individuals in the state of Michoacan as it relates to cartel violence. For example, the more narrow the proffer, the better, because that way you're getting this into the record of telling the judge, this is why I brought this man here. Also going back to the PD theory, communicating your theories with OPLA in advance may allow you to get rid of some of these issues. Like, for example, are these people experts under immigration law? So the definition of an expert, or are we willing to stipulate to their declaration and there's nothing else that they would be adding during live testimony? And another thing to consider will be any credibility determinations. Of course, the judge is the one that makes the final determination. Why are we bringing a mental health evaluator? What are the issues with the past history of trauma that we want to address that may have led or would lead to inconsistencies during the testimony or in the record that's already existing before the judge? So ethical issues to consider with the experts, for example, like I was saying, the confidentiality and making sure that everybody gives the necessary consents to be speaking with each other as third parties, because of course, Anne and all experts are independent entities and my representation of a particular client. What the experts will testify about, what happens if the government objects to an expert being an expert. So we get into that fight during the early stages. We discuss first, is this person an expert? And then going after that fight, we know what the standard that the judge will be using. Will this be an expert witness? Will this be a lay person witness? So if the judge disallows testimony, other than the cheap answer that I can give you that it's an appellable issue for the board, and as Parker's panel was saying, for eventually, assuming things don't go your way, for the Fifth Circuit or wherever circuit you're in, this is something that you have to consider of what happens if this is not going to be considered an expert witness. And you can still ask that the judge consider the expert a knowledgeable witness, or to be allowed to testify as a layperson, and that way you can get this person's testimony on the record. So with that in mind, we can move on to see a final work product of both a country conditions and a mental health evaluation or a declaration. And the experts will each take turns to discuss their rationale behind putting this information in their product.
So we're starting off with, this is my outline of my report, and my reports typically run between 12 and 20 pages by the time I'm done with them. Depends a little bit on the background of the individual and what the claims are, the immigration related claims are. So I start off with my qualifications, which I have a law degree and a PhD and a CSW. So I'm a licensed clinical social worker. I set that out pretty clearly. I explained to the immigration tribunal why I'm qualified and the kinds of things that I consider as a social worker that might not be considered by a different mental health professional, because I do tend to cast a wider net, I think, than many other therapists would do. So I explain that to begin with. I do a mental status report. So the client is awake, alert, oriented, kind of talk about what I'm seeing when I'm observing them. I give a background, personal information. So that is the whole story of this individual, typically from childhood through to the present day. I incorporate things about education. I incorporate things about violence, trauma that they've experienced. And then I do this more comprehensive forensic evaluation in which I administer a couple of sometimes more standardized assessment scales for depression, anxiety, PTSD. I've done a couple where I've also administered ADHD scales because there was some concerns about impulsive behavior in a young adult that stretched back into childhood. So I've started including that as well as an explanation for some of the behaviors that were seen. And then I incorporate all that into my report and explain why concerns that have been explained to me by the lawyers might exist. So if someone crosses the border and they're interviewed by the Customs and Border Protection agent, and they do they tell the first time they tell their story. And we've seen, a lot of us have seen who've worked in detention centers and with asylum seekers at the border. Sometimes those transcripts don't look anything like what your client tells you happened or what the client tells you was said. And so the first thing that happens is they get in front of the next level of the process and they're being told they're not credible because they said something else before. So I'll be looking at those kinds of inconsistencies, and I talk about why that might happen based on my evaluation, my mental health diagnosis. And then I finish it up with the summary, conclusions, and recommendations. Often that involves a recommendation that they be allowed to stay in the United States, but also because they can't get the care or medical treatment that they need in their country of origin. And these are, at least for me, they're typically unsigned, unsworn, they're signed, unsworn declarations. No one has ever asked that I sign them in front of a notary. I don't know if that's common in immigration proceedings, but I thought that's something that occurred to me just now. So I thought I would ask about that. And then we can, so sorry. We prepped this, we really did. Okay, so this is what so that was the overview. This is what mine will look like. So the purpose of the evaluation, I include that. So I have the client's name, a citizen of Mexico, application for asylum. So-and-so, a citizen of Ghana, application for withholding of removal. Somebody else, a citizen of the US, presented for an evaluation in connection with her husband's immigration proceedings. So that would be a hardship waiver for that. Mental status exam, I'm not going to read these to you. This is what it looks like. You can read that yourself, but there's two purposes here. One of them is just thoroughness, because this is something that should be included. And if it was not included, I would expect someone to call me on it. So I definitely include that. But I also proactively address possible limitations on the interview or the interview process, so that I'm not immediately called out by, well, you did it over Zoom or you did it over the phone. You couldn't actually see whether they were this, that, or the next thing. So I put that here in the first place as a limitation. So I don't get gotcha questions at the end. And then the background information would include gender, age, marital status, anything relevant about the family of origin. And then this would also include trauma history here. And then I have that's one of my jobs as an expert is to educate the court or the tribunal and the lawyers. So I always include pretty comprehensive, or I try to include pretty comprehensive information about the diagnoses that might be relevant. So I would include a section on anxiety, a section on PTSD, a section on depression, a section on domestic violence, if that is what we're looking at. So so that would be this, that's an educational piece here. And then I use validated and reliable instruments. I include that references to those so that there's no question about using just sort of, oh yeah, I just looked at this person and I could tell she was depressed, does not go over as well as so-and-so had a score of 34 on the Beck anxiety scale. So we use those for that reason. And then relevant research might include the power and control wheel for domestic violence victims. So this is some of the information I might include there. This is also where I might include information from Human Rights Watch or Amnesty International or the World Health Organization about the access to mental health treatment in the country of origin. And then finally, there'd be my conclusion. And I almost always include my opinion about credibility. I understand that that's a determination for the court to make, but I always include that I feel the client is telling the truth based on the information I've been able to obtain from them and from what is available publicly. So I don't know, I've never heard anyone complain about me doing that, but I have heard that that there might be judges who would get torqued up about it. So I tell you now, that's what I would include. And if Judge Zimmer wants to object to it, let me know.
Now for the country conditions report, what you as lawyer asked the expert to provide an independent, objective analysis of the situation in the given country. In my case, as I mentioned before, I need to, I do write a country conditions report for asylum cases or related to LGBTQ individuals in Mexico. So I need to talk about the situation in Mexico. This person is member of that group, and also it is important to avoid academic jargon. Tell the country conditions expert that you need to use language that neither legal language, because we are not, the country conditions report in many cases are not lawyers. So it is important that it's objective, explain the situation. They need to show that there is a fear of past or future persecution if the person should go back to the country. Also, the credentials should be a paragraph with the relevant credentials for the expert. In my case, I'm a tenured professor of gender and sexuality studies at the University of Houston. I have a number of books and publications, peer review articles on that. So they are those reviewing the documents will know that it is an expert. It is important that when you are talking to the country conditions expert, tell them that in many cases, some of us who are faculty, during different times of our careers, we might be experts on, perhaps my first book has to do with Freemasonry in Mexico, right? And politics of Freemasonry in Mexico. But also my second book, and a dozen of my articles have to do with LGBTQ studies in Mexico. And so as your experts, as the experts please talk about the relevant credentials for this particular case, because maybe you can find a seasoned expert that has 10 books and perhaps all of them are on the country, but in this case, not all of them are relevant for the case. Also, it is important that the expert includes the conditions related to human rights violations in the country. For example, the State Department provides excellent information about the country conditions in Mexico, Guatemala, Botswana, and so on and so forth. It is important to quote that, to give that information. The expert needs to be familiar with that situation, with the situation of human rights, the socio-historical context. For example, in my case, I provide, when it's general about Mexico, Mexico as a country is a Catholic country. The psyche of the individuals is Catholic. However, for example, if I want to argue a case, about LGBTQ individual in Chiapas, and it's also, for example, I would mention the rise of people who belong to the different Christian churches, Pentecostal, and so on and so forth. And I will mention how this church in the everyday lives look at LGBTQ individuals. So it is important to be familiar with, for example, some countries are larger than others and provide the right examples for that particular case. Also, reputable newspapers. There are, like, for example, the Inter-American, the Latin American Network Information Center that tells you which one, for example, are the reputable newspapers in a given country. But also, sometimes if it's a case, for example, of hate crime in Puebla, Mexico, that report, that newspaper article might also appears at the New York Times or the Washington Post. It would be helpful that you tell the country conditions expert, please try to include newspaper articles from the target country, but also from the United States if they are available. Of course, they are not required, but the more the better, especially if are relevant. it is important to try to document what happened. For example, if a person lived in the country in the 90s, what was happening during the 90s, and also what is happening now, and how the country has changed. And also make sure that in the case of Mexico, for example, those of you who are familiar with LGBTQ asylum cases in Mexico, same-sex marriage in Mexico City in 2010 was one of the government's arguments, saying that Mexico was quote unquote a safe haven and they could go back. And it is important that the expert, for example, in my case, as I have argued, I need to tell them the backlash after that same-sex marriage and how that is irrelevant for many transgender individuals in Mexico or many other individuals. So it is important to be aware of the advances of the country, the positive advances of the country in a given situation, but also if there has been a backlash, why and how this would affect your client. Just some parts for the report. Yes, I explained Guillermo del Reyes declares that. I have been asking in the summary, in the request by the attorney, my biographical information that is relevant. And for example, I have done a couple of different country conditions report. One that was more like a report without what I call the affidavit style. And then in the second and third one that I had to do, the lawyer told me that this should be in this way. Communication with your expert is important because some of us have done it probably 10 times, but others might be new. So as we mentioned before, it is important. Then, for me, the summary, it is extremely important as an expert, because I assumed, part of my assumption that we're really busy and the judges are looking at many cases, and here they can see exactly what's going on in Mexico, in the LGBTQ situation in Mexico. So that, for me, that's important, with a straightforward language, and also communicate with your lawyer in terms of like the reading, first one draft, two drafts. Some of us are ESL, English as a second language learners, and sometimes also typos and all that can happen, and it is important to proofread the expert report. The body of the evidence. Here is when I try to give statistics. For example, 75% of Mexicans who are members of the LGBTQ+ community, according to the UN, have suffered violence at different levels. And I talk about hate crimes. What kind of hate crimes have happened? How many trans individuals have been assassinated or killed in Mexico in 2021? All that is important, giving the evidence, and also tailoring the evidence to the client. For example, if the case is about an effeminate gay man, it is important to mention that it's an effeminate gay man. That would provide better evidence. A trans man, etc. Or it could be about other country conditions, but it is important to tailor to the case. So those examples are very important. And finally, the concluding remarks. It is important that you tell, the country conditions expert tell what are the conclusions. So if this person is sent back to the country, they will suffer persecution. Their life will be threatened. It is important too, if that's the conclusion that the expert has, which that was my case, what is what happened, and providing a summary of the relevant points in the conclusion. So that is basically what I do, and I highlight these aspects. And this has in my opinion, my country conditions report has been improved because of my communication with the lawyer. Frank communication, several reading, like as I tell my students, first 10 drafts, it doesn't matter. But of course, telling the deadlines to the expert, telling the deadline is very important. So communication back, communication and objective sharing of information. And that's it from the country conditions.
So thank you both. I want to open it up to any questions. Thank you, great timing.
Time.
I told you
Never
to do
done
it.
that before in our lifetimes.
Right. I want to open it up to any questions from the audience, also the people on Zoom. I'm going to leave up also on the slides our contact information with our email addresses, so you guys can ask anything that we may not have time to address today. Yes.
Helpful for the expert to tell you the argument. So these are the two things that I'm scoring. This is what I want to do. Would that be helpful or no?
So is that directed at the experts, right? You're asking, okay, so the question was, is it helpful for the expert to know we're looking at these two or these three possible PSGs? I think that's definitely something that Guillermo needs to have. A lot of that, I come to the table as a lawyer as well as a social worker. So I tell people all the time, I know enough about immigration law to be dangerous. So I don't practice immigration law, but I do know what they are. So I can usually dive into that without too much of an issue. But for someone that would be a little bit different for you.
Right. For example, some of us country conditions experts don't get to talk to the client for different reasons. So, and also in a situation in like a large country like Mexico, for example, it would be helpful that the lawyer tells them these are the three things that I'm arguing, and then I'm as a country. I said, okay, yes. For example, like one of the lawyers says I'm arguing that effeminate gay men in Mexico suffer more persecution and violence than those who are not. And then I said, yes, I have evidence of that I can prove, and I can tailor my report on that. So I like to provide the large picture in the country and the specifics about the country and the person. And sometimes I have talked to either over the phone or face-to-face with the client, but I would say that 60% of the times it has been with the materials that the lawyer provides to me.
And I also, as the attorney, when I talk to the experts, I like to offer the legal theory of the case in advance and open up a conversation about them. So for example, if I'm drafting a PSG that is related to mental health, I want to know if I'm drafting it correctly, because one of the ways that the opposing counsel can attack it is saying that I am incorrect legally or factually about the PSG delineation. So that's why I want to have that conversation with the mental health expert, or if I'm going to draft something related to country conditions, I want to make sure that I am as accurate as possible in order to meet the three-prong analysis of the PSG, to go back to the PSG example.
It definitely goes both ways. So while I can usually figure out the PSG from just the interview I do, I still want to know where you're going with it, where the lawyer is going with it. And I thought about just now that maybe also, as you talked about, Mexico is such a big country that what happens in Mexico City might be very different from what happens in Chiapas or something.
Right, or in Tamaulipas, for example, one of the last states that approved same-sex marriage. And if the client is from that state, that it is important to mention. So it's relevant to have that communication.
Good question. Anybody else?
Recently, one here.
Oh, sorry, mate. Yes, I missed you.
I'm sorry? Oh, malingering. Do I address malingering? Well, if I believe that the client is not telling the truth or is lying, then I will not agree to do the report. That's an ethical concern from my perspective. If there are concerns about perhaps a personality disorder or some other form of mental health condition that might cause them to exaggerate. But they're still within what I consider to be the ethical boundaries. They're telling me the truth. They're just maybe exaggerating their response to it. That's the sort of thing I'd be talking to the lawyer about. How should we handle this? I'm concerned about these things. I don't feel as though I can, I'm okay. I'm okay with this piece of it, but if you put me on the stand and they start questioning me, the client's got some challenges here. So we would be having that conversation.
And we also have our own ethical duties to worry about. So it's always something that we need to keep as at the very least, a foundation of that conversation with the expert. So where do we draw the line if there's issues like that? And do we need to have a frank conversation about candor, duties to the tribunal, et cetera, with the client to get everybody on the same page, not only as to their narrative, but also our duties to the adjudicator, whether it's the judge or an AO or anything like that. There was a question over here. I don't know who. Yes.
So, as you guys know, I'm sure it happens in cases with the right individual, and then it gets to the last minute. And so the client isn't paid, we expert testify on that day, and that expert has blocked off their entire day. There's another thing to block off. So I'm just wondering, practically speaking, what your thoughts are on order of testimony. And I know that's in case of any situation, I'm sort of inclined from the situation. And my side expert tells me, well, I can charge less if I only have to do for half the day. What is, as far as order of testimony goes, is it ever okay in your experience to have a side expert testify before the response before the final especially money is sort of a cap or something like that?
That's a great question. Let me try to summarize. I know I often mock people who don't summarize well for on the record, the things that happen off the record. So I'm going to be, this is where it comes back at me. So the question is, if it's ever appropriate to have the mental health expert testify before the respondent, when there's other considerations in mind, like, for example, if the respondent has already paid, being low income, like the majority of the clients at the Y, for a particular date for the expert to set aside in their calendar for testimony. I guess the question that I'm going to give you is the law student favorite of it depends. And that's because there's a couple of things to keep in mind. The financial one is something that is serious, and I'm sure even a low bono representation from an expert is considerable, and it's something to not just dismiss because it's low bono as opposed to a full price of an expert testimony. So if that's the sole consideration, then I think it's worth discovering whether it's appropriate by analyzing how you would frame that, or how would you frame your legal strategy. So I like having the country conditions come first, if possible, because it will give us that foundation, especially when it's a country that judges don't tend to see a lot of. I think here in Houston, the majority, and I guess I'll be corrected if I'm wrong, of the respondents being from the Northern Triangle, from Mexico, from bigger countries in South Asia and East Asia and Brazil, for example. Those are going to be issues that sometimes are very recurring. So maybe it's not necessary to have that issue come up first. I have a hearing in a couple of months from a smaller West African country, and the plan is to offer that testimony first, to give that underlying foundation, because otherwise the testimony from the respondent might not on its own give that full context and might leave more questions unanswered than questions answered. But that said, it's something that will depend on will the judge be okay with it and appreciate that consideration being put in their courtroom, and B, the availabilities of the various people that you're juggling during that hearing. Yes.
To follow up on that, so you mentioned low bono, right? So many of us work in nonprofit spaces in our resource strategy. But how can one ensure that they can get both a country conditions expert and a forensics report for free? What are resources? How do we go about it?
Great question.
Grant funding.
Let's repeat the question for the people at home. The question from Parker is, how do people who are generally low income afford having these two types of experts that are at least at this very table? So mental health and a country conditions expert. And the short answer is basically asking around to see who is willing and able to offer that assistance for a prorated price or offer a payment plan. There's various different ways that you can try to negotiate, quote unquote, these kinds of services that we want for our clients. We get a very easy selling point, those of us who work in the nonprofit sector, because most of our clients are at or below a certain percentage of the poverty guidelines. But those of us in private practice don't have the same luxury, and that makes it a little bit harder of a sell to the experts. But it will depend on the individual experts. It will depend on their availability. One of my favorite experts is Dr. Lawrence in one of the Arizona schools. I forget which one, so I don't want to get it wrong on this recording. Sorry for those of you who went to an Arizona school. And he told me that he does 5 pro bono cases per yearly quarter. So he told me that I can either pay a low bono fee, but at the time I was working at Catholic Charity, so I was working in the unaccompanied minors program. So we had to wait until the next quarter. And that said, we had the flexibility of being able to wait until that next time period before we could get pro bono representation. So there's a lot of things that we have to consider when trying to ascertain whether those resources are there. And unfortunately, there will come the time that the client will have to decide, is this something that I can pay? And if not, what can I do to get that service, if anything?
I just want to toss out that I'm really a sucker and I do a lot of work for low bono, but I tend to spend 6 to 8 hours interviewing the client before I start writing the report. And then my report ends up being 15 to 20 pages. So you can imagine that that's a lot of hours that I'm putting into it. And if I'm only being paid, I don't know, $10 an hour for that, it's hard for me to figure out a way to do that as often as I would like to. So it's there needs to be a better solution to that across the board. I mean, that's the first slide today where no one is getting lawyers and they're all losing their asylum cases. We need to have lawyers and we need to have money to pay experts.
Thank you. And unfortunately, we have run out of time. Thank you for the great questions. And again, for being here throughout the day. This slide with our email addresses is still up there. So if you do have things unanswered, at the very least for our panel, feel free to reach out to us and you'll be able to reach out to the entire workshop as a whole later on. Thank you.